Good morning. I just want to check my microphone.
Yes, I can hear you.
Thank you so much.
Good morning. We're now on the record. It's 9 a.m. on Thursday, June 11th, 2026. This is an evidentiary hearing and proceeding number 25AL-0494E, Public Service Company of Colorado's electric rate case. I'm Eric Blank, the commission chair. Can my colleagues introduce themselves for the record? Maybe starting with you, Commissioner Plant.
Good morning, Commissioner Tom Plant.
Good morning, Commissioner Megan Gilman.
Thanks. Let's keep going with entries appearance by the parties. Public service.
Good morning, commissioners. Can you hear me okay?
We can.
Okay, good. That's a good start, right?
It's not a bad start.
My name is Tana Samar Pacheco. I'm Lead Assistant General Counsel for Public Service. Today with me is Pat Zomer from the Cozen Law Firm, Zeb Simpser from Dorsey, and Liz Brahma from Taft.
Thank you. Trial staff.
Good morning, Katie McLaughlin, Senior Assistant Attorney General on behalf of trial staff of the Commission. With me today is my co-counsel, Aileen Chong and Justin Larson.
Thank you. UCA.
Good morning, Mr. Chairman. Gregory Bunker, Senior Assistant Attorney General on behalf of the Utility Consumer Advocate. And with me in this case will be Michelle Singer Nelson, also Senior Assistant Attorney General.
Thank you. Next, I have AARP.
Yes. Good morning. On behalf of AARP, my name is John Kaufman, and I'm also here. Have co-counsel Sophia Faea of the Baker Law Group here.
Thank you. City of Boulder.
Commissioners, Veronique Van Giem, Assistant City Attorney for the City of Boulder.
Thank you. Climax.
Good morning, Mr. Chairman and Commissioners. Richard Fanjo for Climax Molybdenum Company.
Thank you. Colorado Energy Consumers.
Good morning, Austin Rushoff on behalf of the Colorado Energy Consumers, joined by my colleague Fripp Prelo, and we'll also be joined by Michelle King later in the hearing. Thank you.
Thank you. Core Electric Cooperative.
Good morning, Commissioners. Laura Chartrand on behalf of Core Electric Cooperative.
Thank you. Energy Outreach Colorado.
Good morning, Casey Canelio, appearing on behalf of Energy Outreach Colorado.
Thank you. Federal Executive Agencies.
Matthew Vondrasek with the Air Force Department on behalf of federal executive agencies. I might also have Mr. Thomas Jernigan, co-counsel, joining at portions of the proceeding. Thank you.
Thank you. IBEW, Local Union 111.
Good morning, Commissioners and Mr. Chairman. Francis Consiglio on behalf of the IBEW Local 111.
Thank you. Kroger.
Good morning, Kurt Boehm appearing on behalf of the Kroger Company.
Thank you. Sierra Club.
Matt Gerhart appearing for Sierra Club.
Walmart.
Good morning, Julie Clark on behalf of Walmart.
Welcome. And finally, Commission Counsel.
Mitchell DeCenzo of Commission Counsel, and I'm joined by Ruth Harper and Wendy Rosati.
Thank you. Did I miss anyone? All right, moving to electronic exhibits. A spreadsheet marked as hearing exhibit 1500 lists the latest versions of the pre-filed and settlement testimony and attachments. Again, no, we're not admitting all the exhibits on that quite yet. Just regarding that spreadsheet, is there any objection to the admission of hearing exhibit 1500?
Not from the company, Your Honor.
Thank you.
Mr. Chairman, if I could just indicate that we have 4 revised exhibits that are in box. I don't know if you'd like me to move those into the record at this point, or hold up, hold off on that, or do it now.
Yeah, why don't we hold off on that? We'll either do it with the witnesses or after a break or lunch. if you can just make sure the parties have no concerns, that'd be great.
Okay.
With that one comment, hearing exhibit 1500 is admitted. Any objections to omitting all the items listed on hearing exhibit 1500, noting Mr. Bunker's comment about some revised testimony? Ms. Mark?
None from the company. Sorry, I didn't mean to talk over you.
No, you're good. I was talking over you.
I would note along the same vein as what Mr. Bunker raised that we noticed in looking at the spreadsheet that although the PDFs of certain of Ms. Bulkley's attachments were in the record and we had thought the executables were filed, they'd been made available to the party since May, that the executables weren't listed. So we do have a similar issue where we just would like to get the executables available at the appropriate time, and they are also in our box.
Okay, if you could just work with the parties and Ms. Federico, and then maybe after lunch today or after a break, we'll just get the record cleaned up and just make sure everybody's on the same page beforehand. Does that work?
Yeah, thank you.
Next on my list is witness excusal. I do have questions for Ms. Howard and Mr. Goodenough, although my questions for Mr. Goodenough do not require him to listen to anything else. I do not have questions for Mr. Dietenberger. Do you, Commissioner Plant?
No, I do not.
Commissioner Gilman?
Sorry, I'm getting there. No, nothing for Dutenberger.
I do not for Shrub. Commissioner Plant?
I'm sorry. Shrub, no, I do not.
Commissioner Gilman?
No.
How about Lee or Lai?
No.
Commissioner Gilman?
I'm not certain at this time. I understand that witness can't go until tomorrow anyway, so I'm going to see if I can get my couple questions answered with Bouquet.
Okay. Geez, my eyesight. Scheller, Commissioner Plant? I do not.
No, I don't.
Commissioner Gilman?
Sorry, I'm looking. The order has changed.
I know.
Even
I
as
know.
of 5 p.m. yesterday, so I have to look a lot of places. No, nothing for Scheller.
How about Lovely? I don't have anything for Lovely.
No.
Commissioner Gilman?
I have a question that I'm really hoping Freitas can answer. Freitas, I hope I'm saying that right, sorry. I know he is a bit later in the order. So presuming I can get my question answered by Freitas, I would not need Lovely, but it wouldn't be until, let's see, when Freitas is maybe up tomorrow. So it would only be after that I would know if I was able to get that question
And do you
answered.
need Lovely to listen to the prior?
No.
No. So if the company could just keep her available at her convenience, that would be great. Mr. Watson?
No.
Commissioner Gilman?
No.
Mr. Hanson, Commissioner Plant?
Yes.
Okay, so he is not excused. Mr. Miller, Commissioner Plant?
No.
Commissioner Gilman?
Moeller?
Miller.
Miller.
Oh, there is a Mueller. Well,
Yeah,
Mueller
yeah,
has
yeah.
cross. No, okay.
No on Miller.
I mean, we can decide later in the hearing, but do you have question? I don't have questions for Dr. Depew. Do you have questions for him, Commissioner Plant?
Yes, I do.
He is not excused. How about Haho.
No.
Ms. Ho. Commissioner Gilman?
I do not.
Well, actually, I might, but I think Ms. O'Neill, well, she can be excused for now. I think I can get my questions answered with Ms. O'Neill. Mr. Lemare,
No.
No.
Mr. Haglund,
No.
No.
Mr. Rivera Lugo,
No.
No.
Dr. Bongiardina.
No.
I may, but he would not have to listen.
And I'll say the same thing for Ms. Howe, maybe, but she would not have to listen. Ms. Marcella,
No.
Oh, sorry. No.
Nardos, Commissioner Plant.
No.
No.
I have questions for Ms. Anstey. Mr. Fernandez from UCA, Mr. Plant,
No.
Commissioner Gilman.
No.
Let's see. Mr. Kirkendall.
No.
No.
I have a very few set of questions for Mr. Neal, but he does not have to listen. Mr. Ibrahim.
No.
No.
Mr. Brandt.
No.
No.
Mr. Higgins.
No.
No.
I have a couple questions for Mr. Garrett, but he does not have to listen. Mr. Nussbaum, Dr. Nussbaumer.
No.
No.
Mr. Andrews.
No.
No.
Mr. Lako.
No.
No.
Mr. Walters.
No.
No.
Dr. McGovern.
No.
No.
All right, sorry for that. I think we're excusing Mr. Dietenberger, Shrub, Lee, Scheller, Lovely, Watson, Miller, Lemare, Haglund, Rivera Ligo, Bongiardina, Marcella, Nardos, Fernandez, Kuykendall, Ibrahim, Brandt, Higgins, Nussbaumer, Andrews, Lako, Walters, McGovern. Does that match everybody's notes?
I believe, Chair, that I'm not sure if it was Commissioner Gilman said she may have questions for Yen Lee.
Correct. I think I'll get through with okay. But
Hold on,
just in the case, and I think that witness can't go until tomorrow anyway, so it wouldn't be a today issue.
And I think Commissioner Gilman also had questions for Dr. Bongiardina from staff.
Correct. Sorry, I wasn't tracking all what he said.
Thank you.
No problem.
So Lee and okay. Thank you. Does that track for everybody else? Any other further comments on witness Mr. Rushoff?
Yes, good morning. One item just for clarification of the record, Mr. Higgins has testified before this commission, but in this case, we actually have Ms. Courtney Higgins as CEC's witness. So I just wanted to clarify that. And thank you for that excusal. Secondary.
Do you do that on purpose, or only hire Higgins, or?
Hey, they're a great team. So yes, we
Okay.
try to.
Are they're not married, are they?
No, they are related, father and daughter.
Okay.
Yes.
Thank you.
The second item I wanted to raise is you have questions for Mr. David Garrett. If possible, he would like to take the stand on Monday or Tuesday, if that's possible. So I don't believe he's available today or tomorrow. So I just wanted to raise that now. And
You want to
if we
just
could-
assume, say like Tuesday morning?
that sounds great for us. Thank you.
Yeah, and again, he does not have to listen, and my
Okay.
questions will be brief, and maybe Monday we can set a specific time.
Okay, that sounds great. Thank you.
Yep.
Chair, I just wanted to confirm too, the witness Lovely, I had said that I'm gonna try my questions with Freitas, which is a slightly different order than is shown. So it would be after Freitas, I'd be able to let you know. I just wanted to be sure. I wasn't sure if you had Lovely on your list.
I think I screwed that up. So the maybes are Ms. Lee, Ms. Lovely, and Dr. Bongiardina.
For me, yeah.
Yeah, okay. Ms. Van Giem.
I just wanted to clarify if you had questions for Mr. Lehrman, so that we could clarify his availability next week.
I do have questions for Mr. Lehrman, but so does the company. So, I mean, we can see how we go today and tomorrow, but by Friday afternoon, we'll try and give him certainty about when he can appear, if that's useful.
That's helpful. Thank you so much.
Anything else on witness excusal?
I have a witness-related topic, but I can wait on the
All
excusal.
right, that's a nice segue. We'll take that as transition.
With all of the adjustments in cross time occurring over the last 24 hours, we do expect to have some witness availability related issues. If you look at the witness availability tab, there are a fair number of people not available tomorrow on Friday. We can, now that we know who's been excused, we can take a look and see who can be available tomorrow. We're not sure we can fill a full hearing day with availability. We're also thinking that depending on how things go with Mr. Piquet and Ms. Howard, if there's extra time today, we might be able to bring some other people up today. I know that's not ideal for all the parties to the case, so I just wanted to raise it now just to see how you'd like to handle that.
I mean, I'm thinking we'll start Monday morning with Mr. Wenner and Ms. Bulkley, given their availability. And then we'll just have to figure out our best way through today, is what I'm thinking. But I think we're going to have to feel our way through it. It's just unclear how long everything's going to take.
Right. One item of clarification is that on Monday, we will need to start with Mr. Pascucci. He's only available in the morning. So he's available, from 9 until basically we're done with him. It should be fine. But we'll have to start with Mr. Pascucci on Monday.
All right. So on Monday, what's Monday? 12, 13, 14. So on 6/15, we'll do Pascucci number 1, Wenner number 2, and Bulkley number 3 is, and that will hardwire today. Is that the plan?
Yes, that's fine with us.
And then everything else will sort of adjust around those 3. Does that, I assume that works for you, Commissioner Plant and Gilman?
Yeah, so can we go over it today, maybe what we're expecting? That makes sense.
Say again?
Can we go over what we're expecting today for witnesses?
Yeah, I think we're just going to go down the list of company witnesses as on the revised cross-examination sheet, and we'll see about Ms. Lee and Ms. Lovely. And then when we get to Pascucci, Wenner, and Bulkley, we'll skip them and then keep going with Hanson, Nickel, McGregor, Freitas. I mean, the cross matrix says we won't get through with all those witnesses today and maybe even tomorrow. But I think if we get through all the company's witnesses except for the 3 on Monday morning, I think we'll be in good shape.
Okay, so I was looking, it looks like then we have Piquet, then Good Enough, then Allison.
No, I think it's Piquet, Howard, good enough.
Oh, you have Howard. Okay. I wasn't sure if Howard got excused. Got it.
Yeah, I need Howard.
Piquet, Howard, Good Enough, Allison. Okay.
Wait, I
And
don't
then
see
just to be-
Allison.
Just to be clear.
Oh, Allison, I see Allison, correct.
And just to be clear, Lovely would be after Doyle, but I would not know if I have questions for Lovely until after Freitas.
So why don't we plan on skipping Lovely until after Mr. Freitas?
Yeah, thank you.
I would note, Chair, that Mr. Hanson is not available on Friday. So if we don't adjust to have him today, and obviously we need to see how it goes, we should just revisit at the end of the day when he probably would need to go on Monday then as well. But we can sort that out later.
Would you like to move Hanson up just like after Doyle or after Salazar or Deagle?
Yeah, he needs to leave at 4 o'clock today. Is that right? So we could make him available if we get maybe through Good Enough. We could put him after Good Enough if we get that far. If not, we may need to revisit him coming on Monday.
Okay. And do you care, Commissioner Flynn, I think you had questions for him. Do you care the order which he comes as long as he comes?
I do not.
Okay, so we'll adjust on that.
And we do apologize to everybody for having to change witness order. It's one reason we wanted to get that on file yesterday. We've just been juggling logistics. So thank you for your patience.
Appreciate that. Any other witness scheduling issues for the parties? Are there any other preliminary matters we need to address before Public Service calls its first witness? Ms. Consilia.
Your Honor, IBEW has no witnesses to present and we have no cross-examination time. So I would like to be excused from attending all of the hearing in the interest of saving my clients money, but I will be listening to some witnesses.
Of course. Ms. Clark.
Good morning. Walmart's in the same position. Our witness has been excused and we have no cross-examination. So I also request to be excused from attending the entire hearing, but we'll be monitoring it.
Of course. Thank you. Mr. Brown.
Thank you, Your Honor. Same issue with Kroger. We did not present a witness in this case and don't have any exhibits.
Thank you. Of course, no problem.
Thank you.
Any other preliminary matters, Mr. Bunker?
Yes, thank you, Mr. Chairman. UCA and I believe a handful of other parties have a concern with regard to the non-unanimous agreement being considered a settlement rather than just a stipulation between the parties. It is not unanimous. It is not comprehensive. And so we're concerned about the due process issues that may attach to viewing this case as the case centers on the settlement agreement, whereas it's our view, the UCA's view, that the entire case is up for discussion and substantial evidence has to be introduced in terms of each and every issue, whether it's viewed under the settlement agreement or it's viewed based on the direct and rebuttal cases filed by public service and the answer positions filed by the various interveners. And so I just want to get on the record that we have a concern that if the view is that the starting point, if you will, for this hearing is a settlement agreement, that is a concern for us because it is not unanimous, it is not comprehensive, it has not been joined by all the parties, and in particular, the parties that represent the majority of the ratepayers, which are the residential, small business, lower income customers of public service. They all oppose this non-unanimous agreement. And so I just want to get that on the record that we have a concern in that regard.
Mr. Kaufman, I feel like we've been through this at the pre-hearing conference on Thursday. I think we've publicly and in writing acknowledged the concern. I think we've clarified that the burden of proof hasn't changed and that the settling parties need substantial evidence on the record to justify each component of the settlement agreement. So I think your concerns have been noted. I think the record is clear on this. And I don't think there's any further decision or vote to be taken. But Mr. Kaufman, do you have anything to add to that?
I don't add to that argument, just would like to join that objection by UCA and just make that a continuing objection so as to, not burden the record with the continual objections. And yeah, we take some comfort in the assurances that have been given, but of course, the way that the case is ultimately decided will impinge upon that. So just like to make that a continuing objection so we don't need to continue to revisit it.
So noted. Everybody has their due process rights, and this commission will do everything it can to honor those rights for all parties, given the time we have available. And we're doing the best we can, which is why we agreed to allow settlement testimony from the opposing parties, and the continuing objection is noted.
Appreciate it, Your Honor. Thank you.
Any other preliminary matters? Mr. Zemmer, are you ready to call your first witness?
Yes, I am, Your Honor. Sorry, we were just, excuse me, switching over speakers. The company will call Mr. Jason Piquet.
Mr. Piquet, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Absolutely.
Back to you, Mr. Zemmer.
Thank you, Chair Blank. Good morning, Mr. Piquet. Could you please state and spell your name for the record?
Yes, it's Jason Piquet. Last name is P-E-U-Q-U-E-T.
Mr. Piquet, your supplemental direct testimony, hearing exhibit 123, your rebuttal testimony, hearing exhibit 133, and settlement testimony, hearing exhibit 156, along with direct testimony of Stephen Berman, hearing exhibit 101, which you have adopted as your own, have been included in hearing exhibit 1500 already. Do you have a correction to your settlement testimony?
Yes, I believe there's one number that needs updated.
Ms. Frederico, I believe, is Ms. Frederico running box.com?
Yes, it's me today.
Yes.
Thank you. There is a Rev 1 of hearing exhibit 156 in the company's box folder. Could you please pull that up? If you'll scroll down to page 8. So I think we're gonna have to admit this because it's not shown in red line. So we can do this at the end, but if you scroll up, the number 2026, is that the correction, Mr. Piquet?
Yes, I believe that 2026 average number in the top right corner of the screen here mistakenly said 2016. So we've updated that to 2026.
Chair Blank, we'll do this in red line at the end, maybe after lunch, because when we generated the PDF, it looks like the red line, the strike through didn't or got accepted. So
And there's no reason, no need to do this in real time. If the parties don't object, then you can represent that. We'll just admit the revised version, say right after lunch or after break.
Okay, thank you, Chair Blank. With that, Mr. Piquet is available for cross-examination.
Mr. Bunker, I think 60 minutes. You're up, sir.
Yes, thank you, Mr. Chairman. Good morning, Mr. Piquet.
Good morning.
If we could refer to hearing exhibit 133, that is your rebuttal testimony. By the way, while that's being pulled up, if you notice I look to my right, it's actually because I have another screen. And so I am paying attention to you and your testimony, but I may be looking to my right at documents or questions. So starting on page 34 at line 1, here you summarize Piesco's responses to various intervener answer testimony, right?
Yes.
And on lines 8 through 21 on that page, here you indicate that Piesco agrees to a test year using actuals for the 12 months ended December 31, 2025, correct?
Correct.
And when using the actuals for the 12 months ended December 31, 2025, this results in a total base rate revenue increase of $488.2 million or 14.8%, right?
That's correct.
And for the test year comprised of the 12 months ending December 31st, 2025, Piesco's rebuttal position is to use the year-end rate base methodology, correct?
Yes.
And is it your recollection that several parties, including UCA, staff, and AARP, supported using a 13-month average approach?
Yes, certainly staff and UCA recommended that. I'm struggling to recall exactly what the positions were of the other parties.
Okay. And to your knowledge, did any interveners specifically support using the year-end rate base methodology in their respective answer testimonies?
Several parties didn't opine on this. Notably, CEC did not advocate for average rate base.
So the answer to my question would be no intervener specifically supported using year-end rate base. Is that right?
I would phrase it slightly differently. I would say that the company supported year-end rate base. Other parties supported average rate base, and other parties took no position.
Okay. If we could turn to page 35 on lines 3 through 8. Here, using actuals for the 12 months ended December 31, 2025, instead of the direct case proposal to use half actuals and half forecasted expenses and capital additions in 2025, That lowered the revenue requirement by $37.8 million. Is that right?
Yes.
And staying on page 35, lines 9 through 16, here you indicate Piesco's rebuttal position with respect to the 2025 actual year capital structure and costs of long-term and short-term debt, which all were generally consistent with the 2025 test year. But you note that the average cost of capital, or the WACC, was lowered by 2 basis points from the direct testimony revenue requirement study to 7.44%, right?
Yes, the direct case had 7.46% WACC, I believe, and the rebuttal case had 7.44.
Would you agree that in Piesco's recent 2024 gas rate case, that's proceeding number 24AL-0049G, in that case, the commission set Piesco's WACC at 7.0%. Is that right?
That's correct.
And would you agree that Piesco appealed several issues from the commission's decision in that 2024 gas rate case, including the commission's 7.0 WACC decision, and the Denver District Court affirmed the commission's 7.0% WACC decision?
That's my understanding.
And staying on page 35, starting at line 8 through page 39 at line 17. And actually, I think that page number, let me strike that question. I think that page citation, I may be wrong on that. Give me a moment if you would. Actually, page 38. Sorry. Pages 38, starting at line 8, and page 39. Here you discuss interveners' recommendations in their answer testimony regarding Comanche 3 cost recovery, right?
Yes.
And in particular, the interveners you discuss in this testimony passage regarding Comanche 3 cost recovery include CEC, Boulder, staff, UCA, and AARP. Is that right?
Could you scroll down a little bit, Ms. Federico, just so I can confirm? That sounds right. I can't remember.
And I tried to
Yes,
go in the
that's
order
right.
I'm sorry to talk over you. I tried to go in the order you mentioned the parties. So CEC, Boulder are both on page 38. And on the next page, staff, UCA, and AARP are discussed. Is that right?
Correct.
And is it fair to say that each of these 5 interveners expressed concerns with the operational history of Comanche Unit 3 and the ongoing outage issues at the unit?
I think that's a fair characterization. Yes.
Okay. And is it also fair to say that Piesco generally disagreed with the 5 interveners' recommendations regarding Comanche 3 cost recovery?
That is also a fair characterization. Yes.
Okay. And can you confirm for us that the annual revenue requirement for Comanche 3 is approximately $105 million?
In that order of magnitude, yes, I believe it's above $100 million.
Okay. Now, if we could move to the settlement agreement, which is hearing exhibit 155.
It's just gonna take me a minute to scroll down to there. Oh, never mind. I had it up. Sorry.
That's okay. And at the top of that document, Ms. Frederico, it says attachment A, settlement agreement. Yes, it looks like you've got the document I'm referring to. If we turn to page 39. And in particular, paragraph 74. And there's an agreement stated here, a provision that Piesco will file a phase 2 rate case within 12 months of a final decision in this proceeding. Is that correct?
That's correct.
And this promised future phase 2 case can address the topic of a low income residential rate. Is that correct?
Yes, that's the phrasing used in the settlement agreement. Can address.
However, the settlement provision does not say that it shall or that it will address a low income residential rate. Is that correct?
That's correct.
And so is it also correct that the agreement provides that it is up to public service to decide whether it will address this low income residential rate issue in the next phase 2 rate case?
I would disagree with that characterization. This provision simply says the topic of low income rates can be addressed in this future proceeding. It is not specific on who and at what time. So the company could choose to explore the topic. Other intervening parties could choose to explore the topic. The commission itself could choose to explore the topic, and all those are not mutually exclusive, of course. So it's left open.
Well, let me maybe ask it this way. In the advice letter and the direct case filing, public service would have the option, the decision, the choice to make regarding whether the low income residential rate would be included. Is that accurate?
Yes, it's not specified here. It could be included in the direct case. It could not be included.
Okay. And then looking at the last sentence there in paragraph 74 of the agreement, there is another provision that states Piesco will provide a 4CP-AED class cost of service study in this future phase 2 rate case for informational purposes. Is that right?
Yes.
And would you agree this acronym 4CP-AED stands for for coincident peak average and excess demand?
Yes.
And would you agree this is a cost of service allocation method used to assign fixed generation and transmission costs to customer classes based on how much they contribute to the system's 4 highest peak load intervals?
Yes, and I believe that was featured in the company's last phase 2 case from a couple of years ago.
And would you agree that large electric utility customers prefer this method because it rewards their local management and gives them direct control over a major portion of their bill, and that they can produce a large cost savings when they curtail during peak events?
Objection, Your Honor. Mr. Bunker, could you just break that into 2 pieces?
Sure. Would you agree that large electric utility customers prefer this method because it rewards their local? Let me rephrase that. They prefer this method because it rewards load management.
I'm sorry, Mr. Bunker. I wasn't a witness in the last phase 2 case, so I'm not as familiar with party positions taken in that case. I know the 4CP AED was a component of that case to allocate some of the costs at issue. All the party positions are not something I tracked closely.
Okay. I'll move on to a different topic. Let's go to hearing exhibit 156. And this is your settlement testimony. And if we could look at page 44. And lines 12 through 15. Here you state that the commitment to file a phase 2 case is within 12 months of the rate effective date in this proceeding. Is that correct?
Yes.
And that rate effective date per the settlement agreement is August 29th, 2026. Is that correct?
That's correct, as the commission stated in a previous order in this case.
And since that commitment is within 12 months of the rate effective date in this proceeding, does Piesco view this commitment as it could file a phase 2 case at any time during that 12-month period after the rate effective date?
Yes. Yes, it could be before 12 months.
And does this commitment to file a phase 2 rate case contain a bar or a prohibition on public service filing a combined phase 1 and phase 2 rate case?
There is no such prohibition here.
Is public service willing to agree that this commitment to file a phase 2 case within 12 months of the rate effective date will not include another phase 1 rate case filing?
I cannot make that commitment here today. The timing of the company's phase 1 electric rate cases or gas rate cases or steam rate cases are driven by the financial fundamentals of the companies or the company. It's a consolidated company. And so without knowing the outcome of this case, I can't opine on what the future course of phase 1 cases may or may not be.
And Public Service Gas was ordered to file a phase 2 gas rate case by the commission in its 2024 gas rate case, correct?
Sorry, Mr. Bunker, your question was about the last gas rate
Yes,
case?
the last gas rate case, and that one of the provisions of the commission's order was to file a phase 2 gas rate case.
Yes, that's correct. I forget the exact time requirement involved, but the company's currently pending gas rate case is a combination phase 1 and phase 2 gas case. So we adhere to that order. I believe there was a requirement by the end of the year to file that. The end of 2025, rather.
Right. And Piesco filed that commission ordered phase 2 gas rate case in December of 2025, along with a phase 1 rate case. Is that correct?
That's correct.
And is it your recollection that the commission order from the 2024 gas rate case did not include a directive to file a phase 1 rate case? It was only the phase 2 that was directed. Is that correct?
Yes, I think that's correct.
Is it your understanding that Piesco Electric's most recent phase 2 case was 23AL-0243E? So the last phase 2 case for the electric division was roughly 3 years ago. Is that right?
I think that's right.
Would you agree the commission could order Public Service Electric to file a phase 2 in its order, in this case, irrespective of the settlement agreement?
That's within the commission's authority.
Yeah. So you'd agree then, if the commission rejects the settlement agreement, it could still independently order Piesco to file a phase 2 rate case, right?
Yes, just as it did in the company's last gas rate case in 2024.
If the commission modifies the settlement agreement and one settling party decides to make the agreement null and void, could the commission still independently order public service to file a phase two rate case?
Yes, the commission can order the filing of a specific case.
And if we could look at the settlement agreement at page 44. And in particular, paragraph 88. This settlement language creates a modification clause whereby it allows the settling party to withdraw from the settlement upon modification by the commission, and this would render the settlement agreement null and void. Is that correct?
Yes.
And do you agree this settlement provision allows any single settling party to withdraw upon any modification of the agreement by the commission, and that this withdrawal by one settling party would render the agreement null and void?
Yes, that's my understanding of this provision.
And can other settling parties object to a single settling party who puts in writing to withdraw from the settlement agreement because of a commission modification?
That's a procedural question that I'm not sure about. I think in that scenario, if one party were to exercise its right to withdraw, if the remaining settling parties still supported the agreement, I think the option is open for them to continue to express interest in the settlement agreement in that scenario.
Well, if one party withdraws from the settlement agreement, then it's null and void and has no effect in this or any other proceeding. So wouldn't that effectively terminate the settlement agreement?
Yes, it becomes null and void. I'm simply referencing some new provision that would be needed, some new agreement among other parties. But you're correct. The settlement agreement itself becomes null and void if one party were to withdraw.
And there's no language in the agreement that in this clause, this provision that would require the commission's modification to be substantive in nature, such as we're going to change the effective date and move it by 30 days versus a somewhat minor modification like a clerical error. Is that right?
This paragraph did not state with specificity the magnitude of a commission change. So yes, therefore, any change allows a settling party to withdraw if they deem that to be appropriate.
If we could now turn to hearing exhibit 156, that's your settlement testimony. And on page 10, at lines 1 through 10, you indicate the non-unanimous agreement reflects careful and thoughtful consideration of all the issues, a careful balancing of interests and issues to achieve a holistic result, and results in just and reasonable rates that is in the public interest. Is that correct?
Yes.
And is it also correct that UCA, AARP, and Boulder all opposed the non-unanimous agreement, and that EOC was continuing to evaluate its position at the time the agreement was filed? Is that right?
Yeah. Yes, I believe that was the company's positions or sorry, the other party's positions, the non-settling party's positions at the time we filed.
Yep. And do you agree that UCA, AARP, Boulder, and EOC represent the vast majority of Piesco Electric's customers, since their constituencies include residential, small business, lower income, or income qualified customers?
Can you clarify what you mean by vast majority? I'm not following.
Okay, well, public service has roughly 1.4 to 1.5 million customers, correct? Electric customers?
We have 1.6 million customers.
Okay, 1.6 million customers. And of that 1.6 million customers, roughly 1.5 million are residential and small business, lower income or income qualified customers. Would you agree with that?
I do.
Okay. So when I said that these four entities represent the vast majority of those customers, that's what I was referring to. Do you understand that now?
I agree that with UCA's representation, the constituency or groups of customers that UCA represents, as well as Boulder, but I disagree that those organizations solely speak for the interests of other customers. The company cares about all its customers. Staff of the commission has a broad mandate to think about the company's needs as well as customers' needs. Not that those are mutually exclusive, of course, but needs to consider the whole universe. The settlement agreement incorporates other interests here, and so I would disagree that just a few parties speak for a specific group of customers.
Well, would you agree my question did not ask that a few customers, in this instance, those that are the constituency of UCA, AARP, Boulder, and EOC, are deciding the settlement and the value of it?
Can you clarify your question there, Mr. Bunker? I'm sorry.
Sure. You said that I believe your testimony a moment ago was that you were suggesting that UCA was representing that it was making a statement that it was, well, let me strike that. We'll just move on. I think I got what I wanted there. Let's move to hearing exhibit 123, your supplemental direct testimony. And this was your first piece of testimony in this case, is that right?
Yes.
And that's because you adopted the direct testimony of Mr. Berman, is that right?
I did.
Okay. And on page 19, under your statement of qualifications, you state that you were a senior economist at the Colorado PUC, is that correct?
Yes. Yeah, I enjoyed working for the commission.
Yeah. And you were with the commission from July 2016 to December 2019, correct?
Yes, about 3.5 years.
And among other duties, you filed cost of capital or return on equity testimony, is that right?
I did in several cases.
Do you have any idea how many cases you filed that testimony in?
Good question. I would say 3 to 4, maybe.
Okay. If we could turn now to the settlement agreement, which is hearing exhibit 155. And looking at the first page of the settlement agreement, you indicate this is a comprehensive, non-unanimous settlement agreement in the title. Is that correct?
Correct.
Would you agree this agreement is only comprehensive as to the settling parties?
I disagree with that framing.
In what way?
The settlement agreement provides a path forward through all issues presented in this case. The settlement agreement brings into it various items proposed by other parties. In my settlement testimony, I walk through some of those items related to the energy assistance proposals by the company, the prohibited expenses proposals in the settlement agreement, which we adopted some of UCA's ideas on and EOC's ideas on, respectively. I believe there was another topic or two as well that were bringing in ideas that were raised in the case.
Yep. Have you had a chance to read the testimony in opposition to the settlement filed by City of Boulder's witness, Mr. Lehrman, EOC's witness, Mr. Bennett, and UCA's witnesses, Mr. Skluzak and Ms. Henry Sermos?
I have reviewed them. Yes.
After reading those testimonies, would you agree that at least these three settling parties do not view this agreement as comprehensive?
They do not view it as comprehensive because some of their recommendations were not adopted in the settlement agreement. I would disagree that the characterization that the settlement agreement is not comprehensive. It is comprehensive. We consider those elements and we did not adopt that.
If we could look here at the settlement agreement and move to page 28, there is a table, table 3. Okay. The columns that are labeled as balance at 12/31/25 and additional balance through rate effective date. That's what I'm referring to in particular in these in this table. This table 3 is for regulatory assets and liabilities. Is that correct?
Yes.
And here we see a total amount of $20.8 million as of December 31, 2025. Is that correct?
Can I just interject real quick? Mr. Bunker, I think you meant 220.
Thank you. I did. I'm looking at the bottom of the first, or actually the second column, balance at 12/31/25. And I did mean to say about $220.8 million. Is that correct?
Yes, I see that now.
And this is the total of actual historical amounts for calendar year 2025. Is that correct?
Yes.
And then moving to the next column, to the right, the additional balance through the rate effective date. These are projected balances from January 1st, 2026 through August 26th of 2026. Is that correct?
Yes.
And that total in the last row of that column is about $74.2 million, correct?
Sorry, could you say that total again? I'm not sure which number you were referring.
$74.2 million.
Okay, I see that. Yes, that's
Yep.
correct.
And these projects apply to 5 regulatory assets. Is that correct?
I'm counting. Yes, 5.
Okay. And so Piesco's settlement revenue requirement contains at least $74.2 million of non-historical and non-actual amounts that are in fact projected amounts, correct?
Well, some of those are known based on where we stand here today and in May and June when this was developed. I'm not sure the exact split between the actuals and the forecasted here in this middle column. But yeah, some of it would be projected through the rate effective date. I just can't tell you how much.
Okay. And would the reason that public service is reaching into 2026 and including this amount in its 2025 historical test year be because Piesco wants to avoid addressing these amounts and these regulatory assets in its next phase one rate case?
I don't think that's a fair characterization. We're being very transparent about these amounts in terms of the totals being brought into this case and informing the cost of service here. Mr. Freitas could tell you a little bit more of those details. But we're bringing forward all the details here and being transparent about it. All these balances are discussed in each rate case. There's no attempt here to avoid review or anything of that nature.
You'd agree, however, though, that the $74 million here in this column is not included or is not amounts incurred in the 2025 historic test year.
Yes, those amounts would not be included in the year-end balance column right before it.
Okay. Moving to the next column, the total deferred balance column, the total amount of regulatory assets and liabilities is about $295 million, correct?
Yes.
And is it correct that there are only two amounts that are regulatory liabilities, the pension expense and the Colorado tax rate change?
Yes, those are the two negatives here.
And if we could turn to your settlement testimony, that is hearing exhibit 156 at page 39. Here you state on lines 16 and 17 that this case involves an abnormally large amount of deferred costs being amortized in base rates. And this reference here, you were referencing the $295 million that we were just looking at in the settlement agreement, right?
Yes, the costs included in that table, but there's also a few additional items that are in customers' benefit. I would bring attention to the revenue decoupling adjustment balance of about $14 million. The Cabin Creek ITC of about a similar magnitude, the property tax tracker, which is roughly double that, all of which is being provided through the settlement agreement back to customers in more timely ways in most instances, if I can remember, through the ECA. And so if we were to consider those as similar items here, it's actually a lower total.
Okay, in the settlement, is there also over $10 million in annual revenue credits?
Across a few of the settlement agreements provisions on legacy meters and transmission costs and the 2020 WMP, there are several revenue credits that add up to more than that, I believe. But yes, the settlement agreement has has revenue credits as part of it.
Okay, and in particular, I'm referring to paragraph 37D, which is legacy meters. And it's on the top of page 21. And the components of that $10 million, let me kind of just run through this for you. Legacy meters of 1.1 million in paragraph 37D. Just below that in paragraph 38B, transmission and distribution projects, $3 million is the annual revenue credit, correct?
Ms. Federico, that this is the settlement agreement itself, I believe Mr. Bumper is referring to.
Yes, I'm sorry, Exhibit 155. And I'm on page 21. And the first reference was to paragraph D, 37D at the top of page 21. The second reference was paragraph 38B, transmission and distribution projects, that annual revenue credit of $3 million, correct?
So on this page, I see the 3 million from transmission and distribution. Above it, I see the 1.1 million per year. That relates to legacy meters, I believe. And there's also one more category.
Yeah, actually, there are two more. Paragraph 42A, which is on the bottom of page 23 and on to page 24. And the 2020 wildfire mitigation plan deferral credit of $1.2 million. Do you see that?
Yes, I see that at the bottom here.
Okay, and then paragraph 55, which is on top of page 32 is in particular what I'm looking at, but it's paragraph 55 on the bottom of page 31 and top of page 32. And this is a settlement revenue requirement reduction of $5 million, right?
Yes, correct.
Okay, so if you add those four credits, it's roughly $10 million. Would you agree?
I would say it rounds to 10.5, but yes, a little over 10 million.
Okay. And the amount of revenue credits is $10 million in the settlement, but Mr. Freitas's attachment APF 30 shows a revenue credit amount of 13.1 million. And this could be a question I could ask Mr. Freitas, but do you know what that additional $3 million is for?
I would have to scroll through the full settlement agreement to make sure we're capturing all of these items to build into a $13 million number or any other number. The total adjustments in this settlement agreement are closer to $100 million. So it's just a question of how you're cutting and slicing things.
Okay. So that might be a question to ask Mr. Freitas, I take.
If you're referring to a specific piece of one of his attachments, yes, he could answer it.
Okay.
But it's a question about a settlement agreement provision. I'm happy to answer it.
All right. Let's focus on this provision in paragraph 55 that's currently on the screen. And this $5 million for the settlement revenue requirement reduction is also discussed in your settlement testimony. Is that right?
Yes.
And the settlement agreement does not contain an itemization of what issues are meant to be covered in what amount with regard to this $5 million credit. Is that right?
That's right. There's not a specific itemization, but you can see in this provision of the settlement agreement, we are listing a couple categories that this 5 million is addressing, at least in some part. That's the prior case expenses and the 2020 WMP deferral. And there were a few other instances as well during the settlement negotiations that the settling parties kind of looked to this catch-all provision as being important for.
Yeah. Is another way to characterize this catch-all provision as a black box provision?
I think the UCA or any other party could characterize this in a number of ways. We don't refer to it as that. We call it a settlement adjustment, capturing these topics in addition to others that are unlisted.
Okay. And this provision in paragraph 55, this $5 million to reduce the annual revenue requirement, is that right?
I'm sorry, Mr. Rumber, could you ask that again?
I said, with regard to this provision in paragraph 55, this $5 million is to reduce the annual revenue requirement. Is that correct?
Yes, it is a $5 million reduction to the cost of service, and that is a reduction that'll show up on an ongoing basis each year.
Okay. Practically, how does this get credited against the annual revenue requirement?
In terms of the mechanics, you might have to talk to Mr. Freitas. I'm not sure if he included this as a revenue credit or made some other adjustment to the cost of service to effectuate this change.
But you indicated this would be an annual $5 million reduction until Public Service's next electric rate case, right?
Yes, until the rate effective date in the company's next phase one electric rate case, this $5 million adjustment will be in place.
Okay. And if the company files another phase one rate case within 12 months, the new future base rates from that future case will not contain this $5 million reduction. Is that right?
I can't opine on what a future phase one case may or may not include.
Okay. So I guess what I was asking is this $5 million credit may be of short duration in the event Public Service files another phase one gas rate case in the coming months or say year.
If it is a short duration in between this case and the company's next case, then I think that adequately reflects some of these categories that this $5 million adjustment is addressing. The two called out here, regulatory case expenses and a past deferral, are by definition time limited. They're talking about a specific chunk of cost incurred during a specific period of time. To have an ongoing permanent $5 million reduction wouldn't match that.
Okay. Let's look at the next paragraph here on the screen, which is paragraph 56 of the settlement agreement. And in this settlement provision, it states any revenue requirement or revenue deficiency item not addressed in this agreement is accepted as proposed by Public Service in its direct testimony and attachments. Excuse me, as further revised in rebuttal testimony and attachments without acceptance of any methodology or principle. Is that correct?
That's what it states here, yes.
Yeah. And what is your understanding of that last clause, without acceptance of any methodology or principle?
I think what we're referring to in this provision of the settlement agreement is that parties aren't necessarily approving or signing off on every item not addressed in the settlement. Sorry, not addressed. Yes, not addressed in the settlement agreement, but included in the company's case. It's saying all other provisions are as reflected in the company's case unless modified herein. It's slightly different language, right? To say accepted versus approved or something else.
Okay. would it, let me rephrase that. So if the commission were to approve this agreement, it would be agreeing to a number of items and their amounts which get swept into the settlement revenue requirement without the commission or interveners seeing what those amounts specifically are. Is that correct?
No, I would disagree with that. The company has provided thousands of pages of testimony, thousands of pages of attachments, thousands of pages of discovery responses to provide information to all the parties and the commission in this case on its cost of service from a representative test year. All of those costs were subject to examination, and many of them were by the parties. So no, it's not. I would disagree with the characterization that it's swept in. A lot of this has been reviewed, and without acceptance of any methodology or principle, is acknowledging that. It's saying the settlement cost of service and presentation of the settlement agreement results in a reasonable outcome of litigated issues in this case across diverse parties. And we think it results in just and reasonable rates.
Okay. So with regard to any revenue requirement or revenue deficiency item that's not specifically addressed in the settlement agreement, this provision would move those items and amounts into the revenue requirement. Do you agree?
The items not addressed by the settlement agreement would flow into the settlement agreement cost of service. Yes.
Okay. Okay. Would you agree that a technical conference might be necessary to address what these items, whether they're a revenue requirement or revenue deficiency item, not specifically addressed, that it might be a good idea to have a technical conference to highlight what those items and amounts are?
I think that's a determination for the commission to make. The commission often requires a technical conference at the end of a phase 1 or phase 2 rate case. And I think it's often done so in the company's previous cases. We're happy to comply with such orders. So we look to guidance from the commission on that.
Okay, if we could go to your settlement testimony. That's exhibit 156 at page 5 in lines 12 through 15. Here you discuss the credit of over $23 million for 50% of the gain on mineral rights sold and the Cabin Creek ITC. Is that right?
Yes, that's correct.
And is it correct that this $23 million consists of approximately $9.35 million for crediting of 50% of the gain on mineral rights sold in December 2025 and approximately $14 million for the Cabin Creek investment tax benefit? Is that accurate?
That's correct.
Is it also correct that the Cabin Creek ITC amount of $14 million is not delineated in the settlement agreement?
I can't recall if we listed the amount of $14 million, but it was very clear from the company's direct and rebuttal cases what that amount was. So we're simply referring to that.
Okay. And in Piesco's rebuttal testimony, Piesco had already agreed with staff's position to credit the Cabin Creek ITC through the ECA. Is that correct?
I believe we included a provision on how to accelerate the return of that Cabin Creek ITC credit in direct case. I think we slightly modified that in rebuttal in response to staff's feedback. So it's always been a component of this proceeding.
Okay. And this credit for the gain on mineral rights, this refers to the sale of the mineral rights of the Fort St. Vrain mineral rights, correct?
Yes, associated with property around that facility.
And any other mineral rights or just the Fort St. Vrain mineral rights?
Just those.
Okay. So if the $9.3 million is credited for 50% of the gain on the mineral rights sold in December 2025, then would you agree that logic dictates the gain on the sale of the mineral rights was 2 times that amount, or roughly $18.7 million?
Yes, that was the full gain on the sale, of which 50% is being shared in the settlement agreement.
Okay. So given that the company assigned no cost basis to these mineral rights, the gain on sale is equal to the sale price. Is that correct?
I believe that's correct, less some transaction fees.
Okay, and if we could look at the settlement agreement, let me see here which page. I'm referring to paragraph 44, and I believe that is on page 26. And in particular, the table 2, that's on page 27. At the bottom of table 2 on page 27, it shows the gain on mineral rights has a carrying charge at WAC. Is that correct?
Yes, since these gains are being credited to customers over a 5-year period, I believe, in the settlement agreement, that unamortized balance each year grows at the rate of WAC to customers' benefit.
Okay. And if we could go to page 31 of the settlement agreement. Paragraph 54, it states that the crediting of this amount of $9.3 million shall occur over 5 years through the ECA, and the associated regulatory liability shall reflect a carrying charge calculated at the authorized WAC. Is that right?
Yes, exactly.
So help me understand this, because the ECA itself is not a mechanism that has WAC applied to its amounts, correct?
The ECA is predominantly a flow through of the company's fuel costs. There are lots of other provisions that are included in quarterly ECAs. The company and the settling parties here think it's an efficient route to return a specific set of dollars to customers over a specific set of time. It presents itself as a good vehicle for doing so.
Okay, I'll ponder that for a moment, but let me ask the next question, and that is, does public service account for this regulatory liability in its regulated rate base?
It accounts for the regulated liability. Yes. I think the company could in theory return that a number of different ways to customers. And as I was just saying a moment ago, the ECA is an efficient way to do so quickly over a set amount of time and to a very specific dollar amount.
And so is the WAC percentage applied to a decreasing amount of the $9.35 million every ECA quarter?
I believe it would be, yes, as you describe, over a quarterly basis. That I'd have to look at our calculations in more detail to see if we apply that on a quarterly basis or annual basis. But yes, the WACC is applied to the unamortized balance.
Okay.
So customers are getting that benefit.
Okay. Let me ask it this way and see if we're on the same page then. The $9.35 million is subject to amortization each quarter. And so as the amount of the $9.35 million decreases, the balance that the WACC is applied to also decreases.
Yes, over time, that is correct.
Okay. Why would Piesco simply not set this amount of $9.35 million up as a regulatory liability within its revenue requirement model?
There's a number of different mechanisms and time periods that one could return a set number of dollars back to customers. The settlement agreement chose one vehicle and one amount of time with specific provisions around that. There's other ways one could do that, but the settlement agreement landed on this outcome as a reasonable outcome. I think the important piece to note on the spreading out over time is that it was, I believe I can talk about settlement discussions at a high level without attributing it to any party, but there was spirited discussion over how to do this and over what period of time, taking into account intergenerational equity, right? That these property rights have been in place for some time. There's been revenue sharing on those royalties for some amount of time, and thus returning the gain on the sale of those mineral rights or a portion thereof, right? We're talking about 50% here. It's also reasonable to spread that out over time.
Okay. Because if the the balance of $9.35 million would not decrease until the next rate case if it was put in the revenue requirement model, is that correct?
Yes, base rates do not change until you have a phase one rate case. So everything is kind of locked in on your cost of service until you change that in a future case.
Okay. If we could turn to page 27 of the settlement agreement, that's hearing exhibit 155. And this is table 2 here at the top of the page. And the property tax tracker regulatory liability and revenue decoupling adjustment, the RDA, is what I'm focusing on here. In table 2, it shows the Cabin Creek ITC has a carrying charge at WAC. Is that correct?
Yes.
Is it correct that the application of WAC to an amount is known as earning at WAC or WAC earnings?
I think there's a number of ways to describe it. I think carrying charge is probably the most accurate way to do so because that's the company's cost of capital, and thus the time value of money is reasonably represented by WAC. Of course, you can see in this table, not all provisions have a carrying charge and not all are at the WAC. But I think a carrying charge accurately describes the situation.
Okay. So if I understand what you're saying, it's somewhat synonymous, just a different choice of words between earning at WAC, WAC earnings, or carrying charge at WAC. Is that accurate?
Or time value of money. I think a lot of these terms are used interchangeably in our regulatory discussions here.
Yep. Okay. Mr. Piquet, thank you. I have nothing further.
Thank you, Mr. Bunker. I think you hit your time exactly.
Thank you.
Appreciate it. Let's take a 10-minute break till 10:45, and we'll come back with Mr. Kaufman at 10:45. Thank you.
Thank you, Chair.
Mr. Kaufman, you out there?
Yes, I am. I am here.
You're up, sir. I got 30 minutes and it's 10:45.
All right. Thank you very much. Going after UCA helps reduce the cross. And let me just say, I also think that I can waive some cross-examination for some other witnesses. At least for now, I think we can eliminate our cross for Jody Allison and Nicole Doyle. And I see we're the only party that's requested time for those witnesses. So hopefully.
You just, if you could hold on for one sec, Commissioner Plant, did you have questions for Ms. Allison or Ms. Doyle?
No, I don't.
Commissioner Goman?
Allison, I do. Doyle, I do not.
Allison is not excused, but Ms. Doyle is. And with that, Mr. Kaufman, if you need more time with Mr. Piquet, you're good.
Okay, thank you,
sir.
Here, Blake.
Good morning,
Yeah.
Mr. Parquet. Can you hear me?
I think Mr. Zomer had a question.
Oh, okay, sorry.
Mr. Zomer, did you have a question?
Yeah, Mr. Kaufman, if you could keep us apprised, I think you had 5 minutes for Mr. McGregor as the only person. He's got some travel issues, so just as things progress, if you could keep us informed on that, that'd be great. Thanks.
Sure, I will. We'll reassess here later today. Thanks. Good morning, Mr. Parquet. For you.
Good morning.
Yes, my name is John Kaufman. I represent AARP, and I think there's already been some discussion of the fact that the parties representing residential customers in this case are opposing the non-unanimous agreement. Do you know the percentage that residential customers make up of your customer base in Colorado?
Not off the top of my head.
Would 60% of the number of customers sound right to you?
Across our electric system? Yeah, it could be in that realm.
And that's about 1.5 million residential and small business customers, I think, is in that number. That 1.5 million is residential and small business. Is that right?
Well, if we're talking residential and small business, we're closer to, we're 90% plus of our customer base.
Okay. Do you have a sense of how many of the residential customers you serve would be low income eligible, that is eligible for LIHEAP or some other income-based assistance program?
We've talked a lot about that in recent proceedings over the past few years, as well as in our energy and security working group that was in place for a few years following the last electric rate case coming out of the 2023 decision there. And so estimates on that range quite a bit depending on the methodology. We submitted a report on this to the commission. So depending on how you approach it, it can be anywhere from about 150,000 customers up to about 300,000 or 275,000-ish customers. So somewhere in that range. And that's the challenge in all of this, is finding a precise estimate is quite difficult.
And there are programs in Colorado that are available, including LIHEAP and perhaps other, EAP programs. But would you agree with me that there are also many customers who don't qualify for those programs, but that otherwise live paycheck to paycheck? And if that's not clear, we could be more precise about it. In other words, when I say paycheck to paycheck, I'm referring to customers who have no savings and are just barely meeting their monthly expenses with the income that they have available to them. Do you have any sense for how many more customers that might be above the customers who are low income eligible?
I do not believe we've tried to quantify that. It's a sliding scale, right? I think we've focused here in Colorado to date on let's try to understand as much as we can the population of energy burdened and income qualified customers. And that was within the range we were just talking about. If you're then saying, hey, let's understand a broader population of energy burdened or slightly higher income thresholds, that's going to give you a different answer. And I think we've collectively all kind of spent less time comparatively trying to answer that question. I agree it's an important question, but I don't have a number to associate it with it here and now.
Would you be surprised that as many as, say, 40% of Coloradans are living paycheck to paycheck? Does 40% seem too high to you?
I would love to review an analysis on that because I think it's a really interesting policy question.
Well, let's just say no matter what the number is, if someone is living paycheck to paycheck, an increase that goes above their income as a result of this rate case would cause those customers to have to borrow that money, right? In order to pay their electric bill.
I'd agree with a sentiment that for a household that faced socioeconomic challenges, right? Changes in underlying household expenses could increase those challenges by definition. In terms of what the solution set is in response to that, I think there's a whole number of options to explore. Debt is one, support and assistance programs from the utility, from local and state governments, from the federal government, from other nonprofits, right? There's a whole ecosystem of support out there, and that's what we're trying to contribute to and enhance through our EAP proposals here in this case.
And in your testimony, much of the support for your case here refers to inflationary pressures on the expenses that the utility has to pay. Is that fair?
That's one component. It's not the sole component.
And do you know what the general rate of inflation is in your service territory, or the most recent recorded inflation rate?
I believe over the past 3 years, we've been about a 10% change in the price index overall. So that brings it to roughly 3.5% change per year.
Would you be surprised that in March of this year, the Denver area reported an inflation rate of about 4.2%?
That sounds about right.
And that's just for Denver. And based on the non-unanimous agreement that the company's proposing in this case, would electric rates go up higher than that amount for residential customers?
At what moment?
Well, when the rates are put into place as a result of this, of your non-unanimous agreement. I mean,
so it's important.
Well, let me just strike that. And hasn't the company represented that the non-unanimous agreement would result in rate increases of about 5.6%?
Close to that level. Our bill impact analysis based on the settlement agreement is about 5.86% for residential customers, a little bit lower for other customer classes, but in that magnitude. And so on the rate effective date, yes, that would be the change in base rates as a result of the settlement agreement. The important thing to remember is that base rates don't change over time unless you have a phase one electric case. And so there are other riders that change annually or quarterly, but it's important to remember that we haven't changed base rates in about 3 years between the rate effective date of this case and the last case, and we're not sure, right, yet when the next base rate case would be.
Well, if the order coming out at the end of this case increases electricity prices higher than the general inflationary rate that households and businesses are currently experiencing, you'd agree with me, wouldn't you, that that order would have the effect of increasing the overall rate of inflation in Colorado?
All else equal, that statement would be true, but of course we know in the economy all else is not equal, right? There's a lot of things that are changing in real time, or if you look at grocery prices, rent prices, right, other goods and services, housing in particular. Utility costs are one component of that, and there's a lot of studies that show that Colorado's utilities costs are on average the lowest in the country. And so we think our component of overall inflation, our contribution to it is quite small. And we're proud of that.
And the roughly 5.6% impact of your proposal at this point, it doesn't include all the expenses, or at least it doesn't seem to me, and I'd like you to help confirm or not confirm that. In the settlement agreement, and I let me call this up here. I guess it's in page 19 of the non-unanimous settlement agreement. It has referring to the wildfire costs. Is it true that the agreement reduces the revenue requirement that the company was asking for wildfire related expenses?
Yes, this provision in particular, I don't believe it's reflected here. I think it's a little bit lower. Yeah, starting there in subpart B, reduces. Sorry.
Go ahead. Sorry.
Yes, this provision reduces the test year cost of service by pulling out some of these wildfire related expenses, and those will be reviewed in more detail in upcoming wildfire filings.
So the company would expect to then recover those expenses through a rider, right? That is designed to cover wildfire expenses. Is that?
Yes, through the wildfire mitigation adjustment.
So with regard to that adjustment, that doesn't really save any money for customers, right? Because they're going to wind up facing those expenses in a rider. Correct?
If there's no adjustment to those underlying amounts, yes, that's correct.
I'd like to also ask you about the provision in that non-unanimous agreement relating to legacy meters. The total proposed revenue requirement for legacy meters under the settlement is approximately $119 million. Do I have that right?
I don't recall a $119 million figure associated with legacy meters, so you might have to walk me through that.
Okay, exhibit, I think it's attachment 5 on 50 the 15-year revenue requirement line.
Sorry, Mr. Kaufman, are you referring to attachment 5 to exhibit 155?
Let yes.
Okay. And what page or line did you say?
Let me see which line that is. Is the sum here?
Well, does this work? Is this big enough where you can see it?
Yes. Yeah. So that would be that is my sum of the revenue requirement line across the 15 years.
Okay, I see that. Yes, a magnitude of about 119 million sounds right when you incorporate a carrying cost at the long-term cost of debt.
And as far as when you say carrying cost, do you mean both rate of return and long-term debt or debt?
It'd be a carrying cost at the cost of long-term debt. Yeah, I think we're saying similar things.
Right. So over that 15-year period, the rate of return or profit to the utility would be about $30 million. Do I have that right?
I disagree with the characterization of that as profit. Our time value of money is best estimated at the weighted average cost of capital, or WACC. This carrying charge is less than that. So we see this as a component of the settlement agreement that reduces costs for customers. Part of the negotiated outcome here.
But you don't characterize the return on equity as profit to the company?
There's no return on equity here for legacy meters. We have a carrying charge that's below our weighted average cost of capital. And that's below our time value of money.
Okay. So the roughly I guess there's an $11 million credit to the $119 million for legacy meters. Is that right? So would that mean that the rate impact is more like $108 million?
Yes.
Okay. But even with that reduction, that's on top of the return for new meters to the company, right? This is a separate and apart from what Excel is asking for its new meters, right?
Yes, the investment in new metering infrastructure would be part of rate base, as determined in each phase one rate case. And that rate base would receive a rate of return equal to the weighted average cost of capital. So these are related issues, of course, because it all relates to the AGIS rollout stemming from our 2016 CPCN that was approved by the commission, but distinct issues within that.
And am I correct in saying that the impact of new meters is $295 million?
I can't confirm or deny it. I don't have those numbers in front of me.
All right, just one more question on this provision relating to legacy meters. When it refers to the long-term debt, is that under the agreement that you reached with the staff, would that be fixed for 15 years, or is that subject to change in future rate cases?
So you can see in this attachment, it's assuming that long-term cost of debt stays fixed because that's our current
right
long-term cost of debt based on the test year. I understand that will change over time, but the mechanics of that question might be better addressed by Mr. Freitas, who could correct me if I'm wrong.
So in this exhibit, that long-term debt rate of 4.55% across the 15 years is only there for illustrative purposes, and that could be higher or lower in future years. Is that right?
That's my understanding.
Okay. Let me ask you about the end of test year rate base issue. That's do you have a sense for what the dollar value is of that between the parties that your proposal to use year-end rate base as opposed to average rate base? Do you know how much of an impact that issue would have in this case between those two differing recommendations?
So when you compare the two methodologies against one another, there's a couple other side decisions that flow into that, right? Are you also annualizing depreciation expense? Are you annualizing customer counts and revenue, or are you not? And so if you kind of put the whole package together or not, you can get kind of anywhere between $40 million to $60 million is my understanding. But Mr. Freitas can give you a more precise number.
Okay. Well, maybe I should address that with him. But the issues, would you agree with me that the issues that we're wrestling with on that issue relate to the companion issues? In other words, depreciation and other issues, whether they should also be based on a end of year amount to match the test year, the year-end rate base that you're proposing?
I think there's lively discussion of all of that here in the case, and the settlement agreement provides a resolved path through that debate among the settling parties here. We think of course, it's a discussion that comes up in every proceeding, phase one rate case here in Colorado. The settlement agreement charts a reasonable course through that issue in combination with all other issues in the case.
Well, whenever you're analyzing a test year, would you agree with me that ideally each of the components in the revenue requirement should be matched as much as possible in the.
If your question is about the matching principle generally, yes, that's a key feature of rate making. The company would disagree with a characterization if you're talking about average rate base or year-end rate base, an additional kind of averaging or year-end amounts for these companion issues as you described them, right? If we're talking about depreciation expense or customer counts, there can be very valid reasons to not all align them on the same year-end or average basis. Mr. Freitas talks about this quite a bit in his rebuttal testimony, I believe. So I would push that a little bit out of the general matching principle. It depends on the issue.
Okay. Moving on, I want to talk about the Comanche provisions in this case. The non-unanimous settlement would allow for recovery of Comanche 2 costs, even though part of the rationale for keeping it open is to replace the Comanche 3 unit, right?
I'm not going to opine on the rationale for Comanche 2's continued operation. You can talk to other witnesses about that. The settlement agreement charts a course whereby the incremental costs from the operation of that unit would be dealt with moving forward. And that's the settling parties are saying that the PCCA provides a efficient process to do that. We can change PCCA rates as needed to reflect actual costs. There's estimation and true-up processes within that, as well as prudence reviews on the back end. So we think that presents a really helpful framework for capturing these costs that the company is incurring and reviewing them moving forward.
I have a specific question about the I guess paragraph 40 in the non-unanimous agreement. That's on pages 21 and 22 of the agreement. There's a reference to an equivalent unplanned outage factor, XEUOF. And do you have some understanding of how that factor is calculated and applied?
A high-level understanding, but if we start peeling back layers of the onion here, I might have to call on Mr. Hansen or Mr. Pescucci.
So according to the agreement, that there'd be a baseline in this factor, which is related to the number of outages or the extent of outages, and that's at 13.49%. And according in the agreement, that's defined as the industry average for coal units of comparable size. Is that right?
Yes, that's what it says at the top of page 22 here.
And it refers to a 3% deadband as far as Excel meeting this baseline, which means no adjustment would be made if that 13.49% is 3% higher or 3% lower. Is that right?
Correct.
Okay. And then I notice in paragraph 4, I guess, yeah, paragraph 40 subsection E, there is overperformance is referred to overperformance in this factor. And it states that the utility would be allowed to offset any past or future penalties related to Comanche if Excel can overperform related to this outage factor. Is that fair characterization?
Yes, that's a correct way to characterize the mechanics here. And I'd note the importance of that provision, right, to all parties. It was very important that in this settlement agreement that the company not have an opportunity to receive a net incentive from this new performance framework. Subpart E allows for kind of the banking of offsets in years before or after a particularly large outage, if one were to occur, of course.
It helps kind of average it out over time. So we're really tracking to that baseline target over a few years that are contemplated here.
But is the dead band symmetrical in your opinion, or is it is overperformance more likely than underperformance in order to that would cause the utility to be able to avoid future penalties?
I'm sorry, Mr. Kaufman. This symmetry question you have, that it seemed like you phrased that around the deadband itself, or is your question actually around the target of 13.5?
Well, I'm asking this question because it's not clear to me exactly when the overperformance would kick in, and do you know at what number the overperformance would then apply and allow the utility to avoid penalties or offset penalties?
So I think I'll answer your question in two parts here. The first part is the 3% deadband is symmetric, right? So offsets don't start until you get to 10.49. If we achieve an outcome that's less than that, above 3.3, based on the provision here in subpart B, this was very important to settling parties, that the expected D rate of the unit, small D rate coming out of this current outage, be taken into effect. So essentially, right, there's only a pretty limited performance window in which the company could earn an offset here. That's between 3.3% XEUOF and 10.49. Once we're contemplating a scenario that goes, performance scenario that goes above 10.49 in a given year, then we'd have to get up to 16.49 to actually incur penalties. Your question around symmetry on that, or what is the expected value in a given year? I don't have an expected value number. I think the best way to answer that question is to look at the backcast that the company provided as a settlement attachment. I believe that was confidential settlement attachment 6. You can see, based on the performance in certain years, sometimes we're above that. Performing better than that target in a given year, and sometimes we're way higher. And so you can see that the total net amount is not a confidential number, so we can talk about that. The net amount contemplated close to $100 million in penalties over the past 5 to 6 years in that backcast, 10 years. And so there's an expectation of very real penalties moving forward.
Okay, my last area of questions relate to the timing of a phase 2 rate case. And am I reading the proposed non-unanimous agreement to say that a phase 2 that Xcel is committing to filing a phase 2 rate case within the next 12 months?
Yes, that's correct. From the rate effective date.
Okay. Do you have any sense of when that would likely be? Would that likely be at 12 months from now, or would it be more likely to be filed earlier than that?
I think it's standing here today, of course. I think it's likely to expect a phase 2 filing in August of 2027. Whether it's early August or late August, I think that window is well within the 12 months contemplated here in the settlement agreement, but I would expect it sometime between early and late August.
Okay. And to the extent that there may be subsidies between customer classes or inequities in the rate design currently, a rate increase decision from this commission will only tend to exacerbate those inequities or subsidies, right? Because it's going to be applied on an equal percentage basis, even though that may not be what a cost study suggests in a phase 2 case.
A GRSA does spread that out fairly equally. Of course, we have a GRSA in this proceeding as well as a GRSA-E. So there's some nuance there. I would also highlight that the company's current base rates are operating off of a
a phase 2 proceeding that concluded in 2023 and 2024. And so there hasn't been a phase 1 case since then. And so, right, that you could consider that the correct allocation of costs and base rates is currently what's in effect. Riders have their own cost allocation to be reasonable based on the costs incurred by customer class there. And so I think the right way to think about it is the company's current cost allocations appropriately reflect cost causation in many instances. A GRSA applied here could bring that out of balance a little bit, but we're starting from a pretty good starting point.
Well, what is the
phase 2?
I'm sorry, go ahead.
I was just going to say that a phase 2 case in the near future would further bring things back in line to a class cost of service study. So
the mechanism that you're referring to, what is the rate design for that? How are the changes in that rider applied? Are they applied on an equal percentage or applied only to energy?
I'm sorry, Mr. Kaufman, I missed the beginning of your question. Could you say that again?
The GRs, I'm sorry, I haven't got the acronym right, but the rider that you refer to, which relates to certain certain investments, how does that rider apply to rates? Is it applied to all rates, or is it applied to volumetric rates?
Right. So for the residential class, we're proposing a GRSA-E here, right? So it only affects the energy and demand components. I believe small commercial is part of that too.
Okay.
For other customer classes, it's the GRSA component where it's kind of spread across all rates.
Okay, that's helpful. And I think that's all the questions I have. Thank you for your time.
Thank you, Mr. Kaufman. I have 45 minutes for the City of Boulder.
Good morning, Mr. McKay. My name is Veronique Van Giem, and I'm here on behalf of City of Boulder. We would just like to start talking about the O&M expenses and some reliability issues this morning. So the O&M expense in the settlement is 41 million less than in the direct case. Is that correct?
I haven't compared that line item between our settlement cost of service attachment to the direct or rebuttal cases.
Would you like me to take you through that, or?
I'm happy to accept that characterization for the purposes of our discussion. I just want to note that I haven't confirmed that number.
Actually, Ms. Van Giem, I wouldn't mind if you would take us through it briefly. That impacts some questions I have.
Sure. So you can find hearing exhibit 131 attachment APF 20. In the PDF, page 36 is where the line item.
Hang on, I'm sorry, you're going a little bit fast.
Yep, yes, of course. It's Freitas second supplemental direct testimony. So hearing exhibit 131, attachment APF 20.
So there's, okay, APF 20.
Yeah, it's confusing because there are like letters too, but it's APF 20. If you go into the PDF, it's instead of the executable, it's page 36, line 22 shows what the line item for O&M expenses is. So that it shows 749,981,616. You see that? Okay, sure. And then if we go to hearing exhibit 157 and pre-test settlement testimony, attachment APF 30. And so page 27, please. Line 235 is a line item for O&M expenses, and it says approximately 708 million.
Yes, it looks to be about a $26 million change here, that's shown in the last column. It looks like we updated the O&M amounts, I assume, in second supplemental direct testimony, which brought it down from the direct case.
Great. So we've got that established. So from direct down to settlement, it was about probably 41 million less. Are you generally familiar with public services reliability metrics?
Generally.
Okay. Would you agree that public services reliability metrics have been declining in trend in the last 10 years?
I would disagree with that. My rebuttal testimony discusses some of our reliability metrics specifically, and I'm showing how we compare to the industry, that we're actually a better performer on average. I know that there's been a lot of storms in 24 and 25. There's been several PSPS events, which are a new development, which impact some of those numbers, of course. But compared to the industry, we're a good performer. The exact trend over the past 10 years, I can't recall.
Okay. Are you familiar with the answer testimony of Matthew Lehrman regarding O&M expenses?
Yes, at a high level.
Okay. Can we bring up Matthew Lehrman's answer testimony, hearing exhibit 600, page 40?
Yes, it's just going to take me a minute to scroll down there, but I've heard you. 600.
So Mr. McKay, table 5 of Mr. Lehrman's testimony compares SAIDI, SAFE, and KD scores between 2016 and 2025 with and without major event days. Would you agree that this table shows that the reliability metrics have declined over the last 10 years?
In isolation, yes, it appears that these metrics have declined on average over the past 10 years. I'll again caveat that my rebuttal testimony discusses this at length, putting this into a broader context. There's a lot changing with the electric system, there's a lot changing with the company, and there's a lot changing with the climate. That's important to consider when looking at any one particular metric.
Can you speak broadly to some of the evidence that you offered in your rebuttal testimony to support your opinion?
Yes, absolutely. The way we're serving customers is very different now. We have way more variable renewable energy. We've got way more prosumers than we've had in the past. These are customers that use energy at certain times of the day and create energy to feed back onto the grid at other times of the day. We're integrating virtual power plants onto our system. We've had extensive customer growth and starting to see use per customer changes as well in light of that, in light of our electrification trends in heating and in transportation. And so the electric grid, the things we're asking of it are very different now than it was back then. And I'll layer on top of that the weather component here too. In 24 and 25, I think we experienced multiples more of major event days than we have in the past. That's not something we can control. That's not something anyone can control. So that impacts reliability and the operation of our distribution system in real time. Some of those storms have been of a particular nature where we face hurricane force type winds, where we've got to take a really targeted approach to protect public safety and proactively de-energize lines. All of that is new and has occurred over the past 10-year period. So that's just the context that my rebuttal testimony brings to bear.
So you're saying the winds experienced in the most recent years and the major event days in most recent years are different than 10 years ago?
Yes, I think the climate that we're confronting here in Colorado is very different from 10 years ago.
Would you agree that other utilities in the state have experienced the same weather conditions, same or similar weather conditions?
It's probably fair to say that they've experienced similar changes. I know Colorado has a lot of different geographic zones and different weather patterns, so it's certainly going to be more nuanced than that and specific to each region. But yeah, so we're not immune to these changes. I think it's affecting a lot of Colorado energy providers and energy providers across the country, particularly in the West.
Would you agree that public services reliability metrics are lagging behind other Colorado utilities?
Need to see data to weigh in on that.
Sure. Can we scroll to page 42, table MAL7? So Mr. Lehrman's testimony here at MAL7 compares public service reliability metrics to 9 other Colorado utilities. This table shows that the SAIDI score was the worst, both with and without major event days. The SAIDI score was second worst, both with and without major event days, and the CAIDI score was the worst without major event days and second worst with major event days. Do you have any reason to dispute this analysis?
I think it's important to, again, remember this context. I think the specific geographic zones are important here too. I'm not sure exactly, I'm not a meteorologist, so I don't know how these Chinook winds affect all these providers, but I know it's a particular challenge in between the kind of Pueblo up to Boulder areas where we face these hurricane type strength winds in certain storms. I'm sure other utilities have their own challenges, but I would need to see a more comprehensive comparison across metrics. And I think Mr. Salazar, who's our electric distribution witness here in this case, could probably talk about these and other metrics more. I think there's a whole host of distribution metrics that one can look at, and I'm not sure if this is the full universe of them.
Thank you. I can ask Mr. Salazar some of these questions as well. I appreciate that. Can we scroll to page 41? Would you agree that public service reliability metrics have also declined over the last 10 years when compared to the proxy utilities used by PSCO to support this proceeding?
I'm not sure if that's what this table from Mr. Lehrman is representing.
Yes. So table MAL6 shows public services rankings for SAIDI, and CAIDI scores, and they show that they've declined between 2015 to 2024. And Mr. Lehrman compared all of the proxy utilities to public services score. And that's what this table shows.
Gotcha. Thanks for clarifying. Could you repeat your original question?
Would you agree that the ranking has declined over the past 10 years of public services reliability metrics when compared to the proxy utilities?
So based on that comparison over these 2 years shown, noting that the proxy group utilities are going to be in very different geographic zones dealing with very different challenges, right? I think that's an important caveat to apply here, right? If the numbers show what they show, but I just want to bring that broader context into the view here. But I don't have a reason to object to these numbers, not having reviewed them closely. Again, Mr. Salazar might be able to talk more about them for the company in particular.
So kind of going back to when we were speaking about the Colorado community comparisons, you believe that two communities 15 miles apart experience vastly different weather to the point that public services reliability metrics would be drastically different?
Which communities are you referring to?
We can go back up to table MAL 5, please. Oh, apologies. It's MAL 7. I apologize. The city of Fort Collins and the city of Longmont versus the Boulder division.
Yeah, I'm not a meteorologist. I'm sorry, I can't weigh in there. Mr. Salazar might know more.
Understandable. Can we go to page 43, please, table MAL 9? This table shows an average reliability score between 2019 and 2023, and then for 2024 to 2025. Would you agree that public services reliability metrics for 2024 and 2025 lag the historical average?
That's in isolation, that seems to be the case here. Again, just noting the broader context of what we've been talking about recently.
Public service represents that it, moving on to O&M expenses now. Public service represents that it kept its O&M expenses low compared to peer utilities. Is that correct?
I think we've made a general statement to that effect in the company's direct case. I can't recall it specifically.
Sure. Can we bring up page 44? In lines 9 through 12, you'll see here a chart that shows public services O&M expense per megawatt hour that was given as a presentation for Xcel Energy investors in March of 2026. Would you agree that the chart shows that public services O&M expense per megawatt hour is fourth lowest amongst its peer group?
Yes, I agree with that data shown here, and I'll note the customer benefit in light of that. We're keeping costs low. That's why our electric wallet share is the best in the industry. Our rates are below average and our bills are significantly below average. And that's in large part from the results stemming from this exact graph.
Thank you. And the chart shows that O&M expense is approximately half of its peer group average. Is that right?
It looks about half. Yes.
Is it fair to say that public services O&M expenses did not grow as fast as capital expenses between 2016 and 2024?
Not having any data in front of me, I can't completely confirm, but that sounds about right generally, that O&M would have increased at a relatively slower rate, and that largely stems from the company's performance goals of constantly trying to get more and more efficient across all departments, and do what we do better and with less.
And public services net income per megawatt hour of sales was 4 times as much as its O&M expense per megawatt sales. Would you agree with that? Subject to check.
Sure. You'd have to show me the data on that. I'm less familiar with that.
We can go through it. It's in Mr. Lehrman's answer testimony, but it might take us a while to get through the entire calculation. I can show you on page 45, lines 15 through 18. So in the footnotes here, you can see that Mr. Lehrman calculated 185 million and divided that by the number of megawatt hours, about 34 million. In footnotes 81 and 82 to get his conclusion that public service spent $5.38 per megawatt hour on transmission and distribution O&M, but the net income was $23 per megawatt hour.
I think there's a lot of ways you could think about O&M or earnings looking at transmission and distribution costs and assets. Maybe per megawatt hour is a reasonable way to do it. I can think of other ways to do it that would just look on a dollar basis. And so I can't really opine on the validity of those numbers or on the approach. I'd have to think about that more.
Would Mr. Salazar be a better witness to ask this question too?
Mr. Salazar and Mr. Deagle might have thoughts on metrics that are relevant in their distribution and transmission organizations, that they might.
Great, thank you. So, Mr. Piquet, you're saying while reliability scores have declined since the last phase 1 rate case, public service has reduced its O&M expense in its settlement compared to the direct case, is that right? Despite reliability scores declining?
So it's important to clarify that there's a reduction compared to the company's direct and rebuttal cases as reflected here in the settlement agreement. Yes, we've walked through that. That point is true. That is very different than saying O&M expense in general has declined. That is not the case. I believe still with the settlement agreement, O&M levels you can see in the cost of service, those will be higher than what they were coming out of the company's last base rate case in 2023.
Would you agree it's the company's goal to improve reliability?
Absolutely. We want to provide the most reliable and safe and carbon-free energy that's possible. We want to do so as cost effectively as we can. So we've got to balance all these goals that sometimes push in the same direction and other times conflict. And so we've all got to collectively make judgment calls here.
And does the company's testimony in this rate case identify an ongoing revenue need to, or the ongoing revenue needed to restore reliability to the state that it was prior to the prior rate case?
So if your question is what amount of funding is necessary to get certain or all reliability metrics back to where they were in 2023, I don't know the answer to that question. I don't think that's been answered. I think that's a interesting question that could be explored more in a future distribution system plan filing from the company.
And thank you, Mr. Piquet. That is all my questions.
Thank you, Ms. Van Geem. I have 5 minutes for core.
Thank you, Chairman Blank. Core is going to waive Mr. Piquet, and at this time we'll also waive Mr. Fritas.
Okay, thank you.
Thank you.
I have 10 minutes for EOC.
Thank you, Mr. Chair. Good morning, Mr. Piquet. My name is Casey Canelio, and I represent Energy Outreach Colorado, and I have a short set of questions for you today. And Chair, in case I go over a couple minutes, I would like to borrow some time I have reserved for UCA witness, Dr. England.
No worries, that'd be fine.
Thank you. All right. If we could please pull up hearing exhibit 155, attachment 3 to start.
Yeah,
And while that's getting
back up there, thank you.
Sure. And while that's getting pulled up, this is the settlement agreement attachment addressing the bill impacts of the non-unanimous settlement. Maybe we can zoom in a little. Thank you so much. So Mr. Piquet, this exhibit represents the estimated average bill impacts by customer associated with the non-unanimous settlement agreement, correct?
Correct.
And for a typical residential customer, and I think you've stated this earlier, but the exhibit reflects a bill increase of approximately 5.86%.
Yes.
And for the other customer classes, the average increase, it ranges a little less from 5.59 to 4.44, right?
Yes.
Okay, thank you. If we could now pull up hearing exhibit 156, which is Mr. Piquet's settlement testimony, and go to page 22. Great. Yep, we're going to look at this table. So this table, JJPS-3, reflects changes in base rate revenue and total retail revenue associated with the non-unanimous settlement agreement, right?
Yes.
And looking at the total retail revenue line at the bottom, the settlement reflects an overall revenue increase of approximately 6.29%.
Yes.
So the average residential bill impact reflected in your table, in your bill impact table, is lower than the overall revenue increase reflected in this table.
That's correct.
And the average bill impacts shown for the other customer classes are also below that 6.29% overall revenue increase.
Yes.
Could you explain the difference between those average increases and then the 6.29% increase?
So the 6.29 is blending everything together, right? It's saying the change in base rates stemming from this case, which then also has some small follow-on impacts to some riders that are applied on a percentage basis. That's how you get up to the 6.29. The bill impacts should take all of that into account on average. I'll have to double check if the bill impact analysis is keeping some of those rider impacts fixed or not.
11:44.
But I think they're measuring slightly different things. That this is total revenues, whereas the other one's bill impacts.
Okay, I was just hoping to clarify that, so thank you. I think we're going to still have to talk about this exhibit. So Mr. Piquet, just to confirm, you sponsored testimony in support of the non-unanimous settlement agreement. And it's actually pulled up right now.
Yes.
And I want to confirm the settlement agreement does not adopt EOC's proposal to utilize a portion of accumulated RESA balances for targeted bill assistance to income qualified customers, right?
It does not adopt that.
And as we sit here today, would you agree EOC continues to pursue that proposal in this proceeding?
Yes, EOC continues to do so.
Okay. Okay, great. We're already at page 22 of your settlement testimony. So that we just went over this table, but Mr. Piquet, it's titled Settlement Agreement Change in Base Rate Revenue and Total Retail Revenue, correct?
Yes.
And this table identifies various revenue impacts associated with approval of the non-unanimous settlement agreement.
Yes, in total.
And the table compares revenues under current rates to revenues that would result if the settlement agreement were approved.
Yes.
And one of those revenue components is the Renewable Energy Standard Adjustment, or RESA revenue, on line 6 of this table, correct?
That's correct. The RESA is a 1% charge based on certain renewable energy and program requirements feeding into that. So you can see that roughly 2.5 million is equivalent to about 1% of the base rate change in this proceeding.
Great. Thank you for explaining that. So that $2.25 million figure shown here is an annual revenue amount?
Yes.
Okay. And that increase reflects the change to RESA revenues resulting from approval of the non-unanimous settlement agreement?
Correct.
Okay, great. I now want to turn to one of your settlement work papers. It's not part of hearing exhibit 1500. I put the work paper in EOC's box folder. I don't think I need to move to admit it because I just want to go over some underlying numbers to form the basis of your settlement testimony, but defer to the company maybe on the appropriate procedure for going over this work paper. But it's work paper JJP-03.
Is it, it's hearing exhibit 156, work paper JJP03?
Yes, thank you.
I think maybe we just let this proceed and we can address admissibility when you finish up.
Great. Thank you, Mr. Zomer. If we could zoom in maybe a little because the numbers are a little small. Awesome. Thank you. So, Mr. Piquet, I'm going to direct you to line 6. For the RESA, this reflects approximately 35.75 million in annual RESA revenues under current base rates.
Yes.
And under the non-unanimous settlement agreement, line 6 reflects approximately 38 million in annual RESA revenues.
Yes.
And we went over this figure, but that difference between those two figures is approximately $2.25 million.
Correct.
And that same figure is reflected in table JJP-S3 in your settlement testimony.
That's correct.
Okay, great. And so you mentioned this, but just to confirm, the RESA rider is calculated as a percentage of retail revenues.
Yes, I believe it's a 1% charge.
And the non-unanimous settlement increases those retail revenues.
Yes, marginally as shown here.
Okay. As retail revenues increase, RESA revenues will increase as well.
Yes.
And therefore, approval of the non-unanimous settlement agreement increases annual RESA collections by approximately $2.25 million.
Correct.
All right, last set of questions. The current renewable energy plan includes commission-approved RESA-funded programs and budgets. Would you agree with that?
Yes.
And the non-unanimous settlement at issue in this case does not by itself modify those commission-approved RESA budgets or res budgets.
No, we're not making changes to the the res plan or the RISA here in this proceeding, besides these automatic impacts that show up here. It's my understanding from the outcome of the latest res plan is that these outstanding RISA balances will decline over the coming years based on the outcome of that case.
Okay, thank you. So last question, the approval of the non-unanimous settlement agreement increases RISA revenues independently of any changes to currently approved res plan program spending.
Yes.
Thank you. No further questions for this witness.
Thank you. We have 20 minutes for the Sierra Club witness. Do you think you'll need that time? Yes.
I'm sorry, Chair. Could you repeat that question? I didn't hear the last part of it.
Mr. Gerhart, do you have an estimate how much time you're going to need for cross?
Probably a little bit less than the 20 minutes, probably 15 minutes.
Let's take a break till 1 and we'll start with you at 1 p.m. Thanks.
Thank you.
All right, it's 1 p.m. We're back on the record in Public Service Company, Colorado's electric rate case. Before we go, just want to clarify that we admitted all the hearing exhibits, all the exhibits and attachments on hearing exhibit 1500 into evidence, in case I didn't say that properly. And then second, does anybody object to Mr. Piquet revised testimony? That is also admitted. Ms. Canillo, did you have a preliminary matter?
I did, yes. Thank you, Chair. EOC has placed a corrected version of the previously filed joint stipulation in its box folder to ensure the exhibit header complies with commission requirements. The document's been marked as hearing exhibit 704. EOC has conferred with the parties on this and no party has raised any objections. And so EOC would like to move for the admission of hearing exhibit 704, the non-unanimous partial stipulation on electric affordability program enhancements entered into by EOC, the City of Boulder, UCA, and AARP.
Any objections? So moved.
Thank you.
Any Mr. Vondrasek?
Yes, Chair Blank. We also had some items we would like to admit now, if we may.
Since you don't have a witness that's appearing, I think that now would be a good time.
So, Chair Blank, the answer testimony, hearing exhibit 900 of Christopher C. Walters and associated exhibits CCW1 through CCW17, those were filed on April 28th on the PUC e-filing system in a combined PDF. Due to problems with the e-filing system, they were not separated. We've made multiple attempts to file them on the system separated, but we were unable to. So we would move to have those admitted now. They're in our box folder on box.com. I'll also note, I consulted with all parties yesterday, noted that FEA was intending to do this and asked if there were any objections, and no party objected.
Any objections? Hearing none, so moved.
Thank you.
Chair Blank, there's one more on these preliminary sort of issues. We circulated the executable attachments from Ms. Bulkley's rebuttal testimony that didn't get on e-filings correctly. Those are available in our box as well.
Thank you for the clarification.
And sorry, Mr. Zomer, I just want to make sure it's hearing exhibit 133, executable attachments AEB 30, 31, and 32, right?
That is correct. And then Mr. Piquet's corrected version, the Rev 1 is up there now with the appropriate red lines, and we've moved their admission.
All right. Mr. Gerhardt, you're up. I have 20 minutes.
Thank you. Good afternoon, Mr. Piquet. I'm Matt Gerhardt. I represent Sierra Club. Let me know if you have difficulty hearing me. My questions are going to focus on the Comanche 3 performance mechanism. The settling parties are asking the commission to approve that mechanism in this proceeding, correct?
Yes.
And the settlement also proposes a prudence review regarding the current Comanche 3 outage that would be a standalone separate proceeding.
That's correct. Yes, it's the combination of the performance framework as outlined in the settlement agreement and a follow-on prudence review covering the entirety of the current outage.
Okay. And in its testimony in this case, company witnesses have also referred to the possibility of addressing related performance issues at Comanche 3 in the step 2 variance application that's going to be filed on Monday. Are you aware of that at a high level?
At a high level, yes.
Okay. So if you put those all together, the company is proposing that Comanche 3 performance issues would be addressed in 3 separate proceedings over the course of this year and next year. Is that fair?
Yes, there are 3 forums to discuss the operation and performance of Comanche 3. This rate case,
sorry to interrupt. Please go.
As you said, this rate case, a forthcoming prudence review on the current outage and in the Comanche 2 variance case.
Did the company consider combining those issues into a single proceeding to address all of these Comanche 3 performance issues?
Well, I believe the Comanche 2 variance proceedings started last year in 2025. I believe that started before we filed a phase 1 rate case. And so there's some degree of separation here among the issues because we didn't know what to expect in a phase 1 filing from parties here in this proceeding. We didn't necessarily know Comanche 3 would come up in the Comanche 2 conversation the way it did. And we didn't know the outcome of the settlement agreement in advance either of a separate standalone prudence review for the current Comanche 3 outage. So some of this is just a hindsight, foresight issue. So, impossible to address before you know everything.
You're aware that in proceeding 21A-0141E, the commission rejected a performance incentive mechanism for Comanche 3?
Yes, at a high level, I'm aware that one was negotiated among a few parties, but the commission ultimately did not adopt that version of that at that time.
Are you aware that in the company's statement of position in that case, the company offered an alternative to consider a Comanche 3 PIM after the phase 2 just transition solicitation?
I'm not aware of those specifics. I think Mr. Pascucci would be the right witness for that.
Okay. I want to ask you some questions about the potential impacts of the performance mechanism if it were adopted. Would you agree that a potential outcome could be the company increasing capital spending at Comanche 3 in response to this performance mechanism?
Yes, that is certainly one potential outcome. I would say there's a universe of potential outcomes, right? You could have no change in behavior. You could have more capital investment. You could have more O&M spending or less capital investment and less O&M because we're approaching the retirement date. It's a little hard to say here in advance, though I would say in totality, right, the goal of a performance mechanism or specifically here for Comanche 3, right, it's a performance framework that does not contemplate net incentives, is to change behavior or change outcomes. And so I think we're going to look really hard coming out of this proceeding on what can we do to live within the parameters outlined here. Because all the parties are aligned on having steady, reliable service from all of its assets, including Comanche 3. We're going to work hard to live up to that as we have in the past, but now there's a lot of money on the line at the same time.
Okay. So given that increased capital spending at Comanche 3 is a possible outcome, can you point me to any provisions of the settlement that in any way restrict incremental capital spending at Comanche 3? Are there any such provisions?
No, the settlement agreement does not get to that level of specificity of increased or decreased O&M spending or increased or decreased capital expenditure.
Okay. And you're aware that Comanche 3's current retirement date is no later than January 1, 2031, right?
That's correct. And I'll note that the company carries the burden of proof on all of its investments, just like in this phase one rate case and in future rate cases. So we, of course, have to defend our spending on Comanche 3 is the same on any other asset.
Okay. But if that burden to be prudent were a sufficient motivator, you wouldn't need this performance mechanism in the first place, right? If the company's general obligation to act prudently were a sufficient incentive.
I'm sorry, I'm not sure I understand the question. Is it about whether the company was sufficiently motivated in the past or how that changes moving forward?
I'll try to rephrase and let me back up. I'll come in it this way. In your testimony, in your settlement testimony, do you recall talking about the potential unintended consequences of applying this performance mechanism to the year 2030?
Yes.
Okay. Is it fair to say that in that statement, you're referring to the unintended consequences of making capital investments at a unit in the year before it's slated to retire? Is that? Yes.
That's a fair characterization. Yes.
Okay. Where I'm going and what my question is if you're acknowledging that this performance mechanism could potentially have unintended consequences in 2030, why doesn't that same concern apply to the year 2029 or 2028?
Thanks for clarifying. This was a key element as part of our settlement negotiations, and I can't go into those confidential discussions, of course. But the company's rebuttal testimony talks about that exact fact, that this is a unit nearing its retirement date, and so we need to be mindful about the size of the magnitude of any performance mechanism here that's applied. And so we think the settlement agreement is a reasonable outcome of very different opinions on this among the settling parties and thrown out into the case. And so we need to balance a lot of these considerations. But of course, the company thinks it's acted prudently in the past. We always try to maintain the highest reliability from every unit that we can. And this performance mechanism recognizes some of the concerns brought forward by other parties, and we're turning that into a workable framework over these next few years.
The performance mechanism doesn't itself propose any new process or standard by which the parties or commission would evaluate incremental capital spending at Comanche 3. Is that accurate?
It does not change the standard that is normally in place, which is that the company has to support its spending and investment. In a performance framework is a new dimension to those considerations.
The settlement, under the settlement, has the company agreed that normal cost recovery provisions will be different for any incremental capital spending at Comanche 3? I can rephrase if that's confusing.
Sure, thank you.
Sure. The company, through the performance mechanism, has not agreed that shareholders would eat 100% of any incremental capital spending at Comanche 3, right?
Correct. That's not part of the settlement.
Okay. So going back to the idea that one potential outcome is increased capital spending, the company would expect, absent a determination of imprudence, a return of and on those increased capital costs.
In theory, yes. And the reason I hesitate is because there's a pre-settled, pre-commission approved securitization and early retirement of this unit. And so I bring that up because that affects any earnings potential on further capital investment in the unit. So normal investments, normal course of business, that statement's true. It's a little complicated with Comanche 3.
Where I'm going with all of this is it's theoretically possible the company could decide next year on an incremental $40 million in capital spending to avoid a maximum penalty of 30 million. There's nothing in the settlement that specifies the level of capital spending in any given year, right?
That's correct. And I think it's really important to point out the magnitude here, right? $30 million, that there's not a specific methodology underlying that for the magnitude of this performance framework for Comanche 3 performance over these next 3 years, right, with 2030 still to be defined. The company, as you saw in rebuttal testimony, was very concerned by ideas that put the entire revenue requirement of this unit on the line. I think that is a very different place to be in terms of thinking about incremental spending and investment in a plant that's nearing retirement, right? The company operating prudently for customer dollars and shareholder investment would seek to minimize the risk from such an enormous amount that could swing year to year. The settling parties landed on 30 million as a reasonable landing zone, considering all the other issues in the case and the added risk that this presents to the company and customers. Looking over the past few years on the plan's performance, that is a reasonable place to land. We think it balances all these considerations.
Yeah, what I'm trying to get at is I'm not seeing a provision in the settlement that balances the cost side of what you're talking about. I hear you saying that you're trying to balance competing considerations, but I'm not seeing a provision related to incremental costs expended at Comanche 3.
Well, I think it's related to the magnitude that I'm talking about here, right? With a performance metric, right? Just to throw out different scenarios of $10 million compared to $100 million, which is close to the revenue requirement of the unit, right? One would reasonably expect different behaviors coming out of frameworks at those kind of two ends of the spectrum. And so we think $30 million is an appropriate balance of all these considerations of wanting to get as much availability out of the unit in its remaining lives as possible without creating unintended consequences or too much incremental investment to mitigate against those risks. $30 million is a reasonable landing zone to balance all of this.
Chair, I apologize. I didn't start the clock when we started. Would you happen to know how much time I have left? I realize I'm getting close.
You're 15 minutes in.
Okay, perfect. I have just a few more questions. Mr. Piquet, do you recall in your rebuttal testimony referencing the commission's decision in the PIM matter that we were talking about in 25AL-0494E? I can pull up your rebuttal if it's helpful.
Yes, that would be helpful.
Okay.
Thank you.
Could we please pull up hearing exhibit 133 and scroll to page 48? I believe it's lines 1 through 3 that reference the commission's decision on the PIM. Does that help, Mr. Piquet? I recognize you've submitted a lot of testimony.
Yes, exactly. This is my recollection that there was a past conversation around a PIM for Comanche 3 that was ultimately not adopted.
We could pull this down. I want to pull up the decision that you referenced here, and that's in sierraclubsbox.com folder. It should be marked as hearing exhibit 206. I'm not going to seek to admit it. I'm just going to ask some questions about it. And so, Mr. Piquet, this should be the decision that was referenced in your rebuttal testimony. If we could scroll to page 11. And in the second sentence, it says, with regard to Unit 3 especially, one of the primary goals should be to curb all non-essential costs as the plant nears retirement, given the limited life of the plant. Do you see that?
I do.
Okay. And so, at the risk of being repetitive, as we've talked about, there isn't specific language in the settlement that addresses this concern here in the PIN decision to curb non-essential costs as Comanche 3 nears retirement.
Not explicit language, but implicit language based on the structure and magnitude of this performance framework.
Thank you. I appreciate your time. I have no further questions.
Thank you, Mr. Gerhardt. Commissioner Plant,
I'm up.
you're up.
Okay, thank you. Good afternoon, Mr. Piquet.
Good afternoon. Good to see you.
I just had a few questions about the coal plants, and then I wanted to get into some more sort of spitballing on some different things and ways we might be able to address some issues. But related to the Comanche 3 that you were just discussing, that was out of service August through December last year. Is that correct?
Comanche 3 specifically, Commissioner
Yeah.
Plant? Yes, I believe the current outage started in August 2025. I don't know the exact date, but I think in the first half of the month sometime. And it's continuing up until today.
And we're using in at least what you proposed in the settlement, and I think in your direct testimony was a historic test year. So that would look at all the costs through the end of the year, correct?
Correct. Yes, the 2025 test year is a full snapshot of the calendar year. This outage comprises a small portion of that volume.
About a third, I guess.
Right. Right.
So I think I heard when you were discussing the baseline with AARP, that's that 13.5% planned outage time. That's based on an industry average, did you say?
That's correct. I believe that the source of that was CEC testimony in this proceeding, Commissioner.
And I mean, if you're looking at the industry average, you're looking at all the coal plants that are operating today. Is that
correct? I believe that's what their analysis focused on.
Do you have any idea what the average age is of that fleet of coal plants?
I do not, no.
My understanding is that the CPCN for Pueblo Unit 3 was anticipating a 6.7% unplanned outage rate. I got that. I don't expect you to have that handy, but that's from a staff report in 2021 in proceeding 25AL-0494E. And that would fall well within the what's called an exceptional performance level. Is that correct?
Sorry, just to clarify, Commissioner Plant, you're asking would that 6.6% fall within the 13.5, or are these apples to orange?
No, it's
metrics?
actually it would actually be outside of the dead band. So you'd have 13, you'd have another 3%, I guess, below that. That'd be 10.
Right.
So basically, if you're operating at 50% over the unplanned outage, that would be considered under the PIM structure exceptional performance.
Yes, under the PIM structure, anything below 10% it is where the unit starts to become eligible for a short band of offsets here. But I'll note that I can't comment on that staff figure specifically. Just not as familiar with some of those past estimates. Mr. Pescucci or Mr. Hansen might know better, but I'd point out that there's just a very limited band here in the structure in which the company could earn an offset here. That the penalty range is anything above 13.5 or that 16.5 dead band. Each incremental 1 basis point, or sorry, 100 basis points of performance outside of that dead band generates essentially $1 million penalty or offset against future penalties. And so it's a pretty tight window for the company to perform above target.
So the expected number of operating or planned outage days, I think, is somewhere around 25 per year. Wouldn't it be simpler just to provide a base rate credit at the end of the historic test year for any days over that 25 days that was a part of that CPCN, and just reduce the base or the rate base request by that much? I mean, wouldn't that, I mean, we've got a situation where customers have already paid for these 3 months. The unit wasn't operating those 3 months. Wouldn't it just make sense to credit the revenue increase by that amount rather than going through this sort of this PIM structure that uses, you know, a planned outage rate that isn't relevant to this particular unit, or, you know, making up a number like 30 million because it was sort of just a compromise number. I don't understand why it wouldn't just be easier to take the number of days and reduce the revenue requirement by that much.
Well, I think that the key difference there, Commissioner Plan, is that you're presupposing that the company's actions, you know, leading up to and after an unplanned outage were imprudent. And I think the important thing to highlight from this whole performance framework is that parties in this case have expressed concern around this unit's performance in the past. This is a framework to think about that over the next few years to align all of our incentives here. And we've also got this standalone prudence review to look at this outage in particular. And so I think, right, a lot of our discussions and during our settlement process focused on this exact question on what is the right baseline, how to think about planned versus unplanned outages. There's lots of different metrics and estimates floating around. The important thing to highlight there is that the amount, my understanding at least, Mr. Hansen can tell you more, is that the amount of planned outage time can vary year to year. And based on the needs of the plant, how it's operating, what we found during previous maintenance outages. And so it's not a static, you know, 25 days as you cite, or something higher or lower than that. And so the importance of the XEUOF metric is that it focuses on unplanned events. It's saying when we think the unit's supposed to be operating, is it actually there and ready? So these planned items are taken off the table, and we all want to encourage those planned maintenance because that's important to encourage reliability and availability moving forward. We don't want to have a perverse incentive to not do that maintenance work.
But if there's and I don't want to belabor this point, but if there's a CPCM that's based on a 6.7 or 25 days of planned outage, that's kind of the basis for which this unit was approved. I'm just thinking wouldn't it be a little easier to say, yeah, maybe you had an argument for why days more than 25 are prudent or not, you know, or aren't prudent, but can't you just argue that within the case? You know, you've got, say, 100 days, you're allowed 25, so there's 75 days of question, and you know, you can make your argument for why that should be 70 or why it should be 60. But at the end of the day, we just take the number of days that are determined to that fall outside of the CPCN that, you know, are not considered prudent, and just subtract that amount that people have already paid for the unit. And then it's a much less complicated and sort of debatable structure of a PIM.
If I'm understanding you right, Commissioner, I think that sounds a lot like the framework that staff was presenting in its answer testimony, right? Looking back
I
to
think they
past
had a
proceedings in which
performance.
there's
Yeah, I think they had like they were saying to recover through the days that the unit was operating, which maybe is a little bit different. I'm just trying to go back to what the unit was approved based on and then, work out from there. But anyway, I just wanted to get your thoughts around, just a simpler structure that wasn't based on other, maybe 45-year-old coal plants.
right. Yeah, I appreciate the the spitballing here to use your term. I think that Mr. Pascucci and Mr. Hanson can weigh in on metrics more. My understanding was just suggesting it might tweak the metric a little bit, but seems a little bit more aligned with what staff was outlining in testimony. And I would just note that through the settlement process, we all discussed and debated this a lot, and we came to a resolution that the framework in the settlement agreement is a good place to land. That there are a lot of perverse incentives created by putting more money on the table. There's also a lot of concern expressed by parties by not having anything on the table. That this was a reasonable metric and a reasonable amount of money on the line each year.
Okay, moving on to the issues around Craig 1, and I know that I forget the sort of term of art that was used, regulatory something or another, basically trying to talk about the federal government. I think it was some sort of a term. My understanding as it relates to Craig 1 is that there was a 202C that was issued to Tri-State. Is that correct?
That's correct.
So this issue is certainly currently being litigated between Tri-State and the federal government. I'm trying to understand what that issue has to do with public service ratepayers.
This is a topic that Mr. Pascucci's testimony deals with in more detail. I think the extent to which it comes into this case, we're talking about costs, incremental costs to keep that unit running beyond its planned retirement date, of which a portion of which could be the responsibility of Xcel Energy and its customers. We present a PCCA rider route to handle those incremental costs.
I guess what I'm wondering
Through the
is
settlement
why.
agreement.
I guess what I'm wondering is I get that it may be a cost to Xcel. I'm wondering why it's a cost to the customers.
That's a good question for Mr. Pascucci. I think he can give you a little bit more detail there. His rebuttal testimony goes into that.
And I can talk to him about it more, I guess. We're operating under the presumption that what the federal government is doing is lawful. Is that correct?
I'm sorry, I can't opine on that. I know that there's debates on this happening at various forums that I just don't track closely.
We've kind of been stung by that in the past. The assumption that the federal government is operating lawfully and trying to get some tariff money back right now. So I do have some other questions just specifically for your colleagues, but I wanted to just talk to you real quickly about, big picture in terms of the credit ratings and credit worthiness of the company and that sort of thing, and what we try and do during these rate cases to try and address those issues. It seems like, this comes down, nobody wants to increase the cost of debt because of some kind of a downgrade, although there's been some discussion around what that relative cost actually is. But it seems like most of the issues that speak to the credit worthiness of the company come at a cost to ratepayers. whether it's increasing ROE, which increases the WACC, or increasing the equity percentage that increases the WACC. And even the settlement, which reduces the WACC from the request from the company, is actually an increase over the current level. If we look at the rating reports, certainly wildfire liability risk is a huge part of their consideration. I think I saw it in all of the credit reports. And I would suggest that the wildfire mitigation plan goes a long way towards addressing that risk, although it doesn't seem to be fully recognized by the credit rating companies. Again, that's at a significant cost to ratepayers of a couple $2 billion. The PSPS, which mitigates that risk, again, costs that are borne by ratepayers. Do you see any approach that would balance some of those costs as they're deployed between the falling entirely on the customer base versus sharing with the company?
Well, I think we're seeing a lot of the sharing of the risk here on a few specific topics. In this case, and certainly broader when we take a step back. The Community 3 framework, as we've been talking about, right, puts real dollars on the line for company performance, as does the DCA PIM, also contemplated in this case. The company has more than a dozen other performance incentive mechanisms, some of which are symmetric, some of which are just downside only. Right, when you look across QSP plans, other cost to construct, other availability PIMs.
Those are performance. I get that those are performance-based things. I'm just concerned. I'm looking at what the rating agencies are looking at for creditworthiness, some of the issues that they bring up, how those issues really redound back to the customer base in increased rates. I'm just wondering. I mean, clearly, if we can mitigate harming credit to the company, that benefits everybody. But it seems like the costs of that really fall on achieving that really seem to fall on the customers. And I'm just wondering how we might be able to think about balancing that. I think Boulder's come forward with an idea about a recovery fund for the businesses that end up paying the costs of the PSPS. I know that there's been a number of folks who have brought up the issue of getting some sort of reimbursement from the company. Right now, there's really not an incentive for the company to not do a PSPS, other than it really kind of pisses people off. But, I mean, there's no financial hit to the company, really. I'm just trying to figure out how do you want the company to use it when it's necessary. We get that. Everybody wants to lower the risk of wildfire. It's just how should we think about balancing that financial obligation?
So maybe I'll address your credit metrics question or credit quality piece first, Commissioner Plan, and then turn to the PSPS element. On the credit metrics front, I agree with your statement, right? That we've got to find the balance here on what is minimizing our cost of capital. That's our goal. And so that it's the commission's obligation, it's commission staff's, it's the companies to maintain our financial integrity so that we can bring safe and reliable service to our customers. We think this settlement agreement, by putting more than $100 million in adjustments onto the table, brings down those costs for customers. It's a reasonable result of all these litigated issues, of which there's lively debate on. And it gets our credit metrics to a place that is kind of just above the thresholds that we're targeting to maintain our current ratings, not to try to improve them, to maintain them. We don't think there's a lot of wiggle room there, and I think it's not a surprise that you see the settlement agreement landing where it does. And Mr. Wayner can go into more detail there, of course. You also see from the credit rating reports, credit rating agency reports, that there is absolutely a discussion of wildfire risk, and that continues to evolve in the American West, but also of business risk and regulatory risk more generally. And that's what brings us here today, right? Talking about the company's investments and the regulatory recovery that's afforded to those. On the PSPS side of things, Boulder's ideas on that are interesting, and we're happy to talk about those. I think our point in rebuttal was that let's talk about those in the ongoing M docket, and it's my understanding that there could be a rulemaking on this front in the near future. And the settlement agreement actually contemplates additional metrics for the next electric QSP plan, probably filed within the coming year, to address additional metrics. One for the WMP and PSPS elements, as you describe, and another, I believe, was a call out to power quality. And so there's forums to talk about this moving forward. We just think there wasn't sufficient time or record built out in this case to kind of develop something here.
Do you think the QSP is sort of the best place to do an evaluation of performance metrics that might be then tied to the recovery and that's decided in other cases?
I think the electric QSP is a really good venue to talk about what are our collective goals, right? What are the metrics we want to target to and have incentives and disincentives around those. I think the company's forthcoming WMP to just focus on a particular topic of spending and investment here is another good place. Just as the upcoming company program filing on July 1st is a good place to talk about incentives and program design more broadly for customer programs. So I think there's a lot of forums where you can tackle the specific question that we're all interested in. It's hard to do it all in an electric rate case, of course, but we think we've moved the ball here in a constructive way in the settlement agreement.
Yeah, I mean, I think we've sort of run into this issue in a variety of different cases, whether it's the DSP or
That's another one.
or it's
Yeah.
an all rate case. One of the things that I think Boulder brought up was also, using maybe that QSP performance evaluation to reflect on an ROE level. I'm not sure exactly how that would work mechanically, but I think that was another thing that was brought up as well. And that kind of brings me to another issue I'd just like to get your take on. The final area of sort of creditworthiness that the company brings up, and one that I don't think has a specific cost that falls on the ratepayers is regulatory lag. The issue with ratepayers, I think, is performance and, are the costs that are included, are they justified and all those sorts of things. That's, with a forward cost recovery, those are the issues that come up as opposed to, specifically, increasing the costs in some way. And so I wonder if it would make sense and maybe to think about as a way to kind of meet in the middle would be to do that kind of forward projection, but tie it to performance indicators. And so that you can ensure that there is, you're achieving the performance that's promised within those expenditures prior to that when they are happening, but you don't wait till the next rate case to collect it, but you collect it based on the achievement of those performance indicators. And whether or not, or maybe you get 50% upfront and you get another 50% based on achieving certain performance indicators, some sort of structure like that. That would, it seems to me, address the issues that the company brings up regarding regulatory lag, but also address the issues that are of concern around actual performance and achieving certain objectives. Is that something that the company might be interested in pursuing?
Yes, yes. Happy to have those conversations, Commissioner Plant. In a nutshell, it's yes. I'll call out that the last settlement agreement from the 2022 rate case, right, just decided, which the commission approved in 2023, had a provision for that all the parties would come together through an M docket and kind of explore some of these rate making, cost of service, performance questions to think about, is this the right paradigm that we're in right now, or should we think about different ones that exactly as you're describing and potentially others? We didn't get around to that because there's a lot going on, right? There's not only in these phase one rate cases, right? We've had a lot of complicated planning proceedings that we want to spend sufficient time and attention on. And it wasn't something that we could find a lot of traction on among us as well as some other parties to find the ability to focus on that. So the company's happy to have that conversation moving forward, right? There's a long history of the company bringing forward test years or other ways of thinking about regulatory lag, which is hard for the company to manage around. And other interveners, in this case and others, expressing preference for new or different performance metrics. So the conversation is always right, Commissioner.
Thanks. Mr. Chairman, that's all the questions I have. Thanks.
Thank you, Commissioner Plant. Commissioner Gelman.
Thanks. Good afternoon, Mr. Piquet.
Good afternoon.
I have first some questions for you about the Pueblo Unit 3 framework. So when we look at Pueblo Unit 3, I see kind of three main issues. First, there's the rate base and the inclusion of the plant in rate base. Then there's the cost to repair it, as we look at the outage specifically as an issue. Cost to repair it, and then the replacement power cost. So is it fair to think of this that the framework or PIM setup here or presented in the settlement is just addressing the first of those, how it comes through in rate base?
I think that's right. Yes, we're addressing the cost recovery piece and performance moving forward at the same time. The questions around, right, what incremental investments or expenses were incurred to get the unit back online in 2026, what the replacement power considerations are, I think are all topics to be explored in the standalone prudence review that the settlement agreement contemplates, and potentially in a future phase one case if those investments or expenses are at issue.
Okay, got it. I want to make sure I'm thinking this all right. And then within the settlement agreement, the suggestion is that, or the commitment, I guess, is that the company would file that standalone prudence review by July of 2027, correct?
I think it says June 1st, 2027, but yeah, sometime in that time frame.
Okay.
I might have the wrong date, but yeah, sometime in early summer of 2027.
June, you're right. June 1st, 2027. Okay.
Right.
All right. And what is the first year in which the Unit 3 PIM would be applicable for performance?
The settlement agreement contemplates that it is applicable starting on the rate effective date from this case. So starting on August 29th, this performance framework would take effect.
And when do you expect to have Unit 3 back operating?
My understanding, based on what we said in rebuttal, is before the rate effective date, sometime this summer. So I don't have an exact date here, but I think sometime in July or August.
Okay. So it would not cover any of the portion of this year in which that plant was in a
That's correct.
outage.
Yes, Commissioner Gillen. The thought is that the standalone prudence review would tackle all of that.
Okay. Wanted to ask about something Mr. Lehrman had a concern about in his testimony. First, he cited no affirmation that the operational use of Unit 3 would continue to follow the parameters agreed upon in the settlement in 25AL-0494E, which was the company's prior ERP, which set the retirement date for Unit 3. Can you confirm if it is your intention to still abide by the operational restrictions set forth in that settlement agreement?
As far as I'm aware, as I sit here today, yes, we haven't made any proposals or motions to change that. If you want to talk more specifically around the operational thinking around the unit, I'm sure Mr. Pescucci or Mr. Hanson can probably go more in depth there. But yes, we haven't proposed to change any of that here.
Okay, gotcha. And then Commissioner Plant had asked you about the average age of plants kind of in your average or baseline number being used for the forced outage rate. Do you recall that?
Yes.
And as I understood, you didn't really know the kind of arrangement of ages within that average that's being used.
I don't. Sorry. Yeah, I really don't.
Okay. I guess, is it fair to say that the Pueblo Unit 3 coal plant is one of the newest coal plants in the country?
I'm honestly not sure. Mr. Hanson might have a better understanding of coal units around the country, but maybe not.
Do you have an idea if it's a relatively young coal plant?
As someone who spends a lot of my time focused on gas planning and cost recovery, I don't know a lot about the specifics of our generation fleet and how that compares industry-wide. But others might.
Okay. Okay, let's see. Does the unplanned outage rate, and correct me if I got the wrong terminology there, you can fix my terminology, but does the outage rate that you're proposing here for this PIM have any relationship to what is being used in resource planning?
Are you referring specifically to the XEUOF metric?
Correct.
Commission? Yeah. My understanding is that reflects the metric that some of the more recent availability PIMs are designed around for some of the company's newly approved units. So I think we've got a lot of similarities there, but Mr. Pescucci knows all those details. If you need to go further on that.
So you're not sure if this is a value that's used anywhere else in resource planning to rely
It is, yes, I can definitively say that, right? It's a metric that we track. I think it's used externally here with the framework of some of these performance mechanisms moving forward on new units. It's the metric that we're tying the DCA PIM to as well on unit by unit for the company's existing thermal fleet, as well as Cabin Creek and some other dispatchable units. So it's very widely used by the company here in terms of industry wide, right? How often it's used compared to other metrics. Mr. Hanson might be able to tell you more.
Well, and I just wanted to clarify, I wasn't necessarily asking about the metric, but the value of the metric that you are using to set the baseline for the PIM. Is that value carried over in any resource planning or other uses?
Oh, sorry. So specifically about the 13.49% value, is that used anywhere else? I'm not aware of that being used anywhere else. I think that number came in this proceeding, right? As I was talking about previously with Commissioner Plant. I believe it stems from a piece of CEC's answer testimony as a way to think about evaluating the company's performance on this unit.
Okay, so that's not necessarily recognized in resource planning as the company's expectations for the plant's performance.
I think that's correct. I'm not aware of us using that specifically, but Mr. Pescucci or Mr. Hanson could confirm more definitively.
Okay, will do. And then kind of in relation to some of Mr. Gerhardt's questions for you and concerns we saw in Mr. Lehrman's testimony, there were concerns that there is no capital or O&M restrictions or boundaries necessarily related to this PIM in terms of what could be spent on Unit 3. Is that correct?
Yes, the settlement agreement does not contemplate specific language on that.
And then in your rebuttal before the company essentially agreed to this PIM, in your rebuttal, you had indicated that staff's approach, meaning the approach, as I take it to the performance metric impacting specifically Unit 3, quote, would significantly affect how the company approaches planning and investment in Comanche 3, a unit that's just a few years from its retirement. So I was wondering if you could elaborate for me on how you view this PIM significantly affecting the company's planning and investment in the unit.
And are you referring specifically to the settlement agreements, $30 million for the unit, or answer testimony from other parties?
Yeah, to the 30 million's fine. I mean, if you think it will not any longer significantly impact your planning and investment in the unit, let me know.
Well, I think that gets to my conversation with Mr. Gerhard, which just wanted to know how you were thinking about it, because it's as a prudent operator, right? If we've got a $100 million swing potentially year to year based on how the unit's performing, based on a $30 million swing year to year, that's going to affect some of your spending and investment choices by definition, right? With an extreme amount of dollars on the line, we would be imprudent not to do everything possible to keep that unit online, even if in the broader picture, that wasn't the best idea. And that was our chief critique of an amount of that magnitude. We think $30 million mitigates a good chunk of that concern, but it's still a lot of money on the line each year. So it shows continued skin in the game from the company's perspective. I think an amount of that magnitude, right, the whole purpose is designed to change behavior. We're going to do everything we can to keep this unit available and online. And we think we've tried our best in the past. Now there's, even more on the line here. And so what we think it's an appropriate amount.
Okay, so I guess what I'm hearing is you think that the level at which that PIM amount is set will, I guess, cause you to make the most prudent decisions about what is too much to spend, the right amount to spend, to maintain the reliability of the unit moving forward?
I think, yes, I agree, Commissioner Gilman, with that framing. And I think that's the whole purpose behind a performance mechanism, right? It's essentially the commission or parties, right, saying, hey, this is how much we value a certain outcome. And so with that information in hand, that's going to affect the company's decision-making thereafter. That's the whole purpose. And so with an extreme amount on the line each year, a full revenue requirement of the unit, as some parties are suggesting at the start of these discussions, that's a very different place than where the settlement agreement lands, which is a much more balanced and workable approach from the company's perspective.
Okay. And so I understand like the company's profit motives or potential penalties may be new, but the company's responsibility to ensure that they're spending what is necessary and prudent and not more for reliable operation of the plant to operate in the public's interest. I guess I'm not clear why that didn't exist before.
I wouldn't say it didn't exist. It absolutely existed. The company works really hard, and it's Mr. Hansen's job, and he can talk about this much more than I can, to make sure our units are performing well and available when we need them to serve customers. We have an inherent interest and motivation to do that. We care about our units, we care about our employees, we care about our customers. That all goes into the performance of any particular asset, and particularly this unit here in question. An additional performance framework around that further incentivizes it, right? That's the whole purpose of a framework. Parties have been frustrated at the performance of this unit. We've been frustrated at times too, and this is us aligning around how to think about this over the next couple of years.
Okay. So then if you had this inherent incentive before, now there's more of a financial kind of value put to it for the company. do you foresee significant changes in the capital and O&M expenditures the company is putting in the plant in the coming years?
It's a good question. I'm not privy to any decisions we've made one way or the other. I think we're very curious in the outcome of this proceeding and the settlement agreement in particular. Mr. Hansen can talk a lot about the continued operation of this unit. We know it's nearing retirement, right? As I was talking about a lot with Mr. Gerhardt, we're going to keep that in mind, right? It's not in anyone's benefit to continue to invest significant sums in a unit that's nearing retirement.
Okay. And then question for you in understanding there are no boundaries around this in the settlement agreement, and that's clearly of concern to several parties. Do you think it would be in the public interest for capital and O&M related expenditures on the plant to increase disproportionate to any improvements in reliability in the coming years?
I'm sorry, Commissioner, could you ask that question again? I wasn't tracking.
Yeah, if we see increases in capital expenditure and O&M expenses for this plant that are disproportionate in relationship to increases in reliability of the plant in the coming years, do you think that would be in the public interest?
Well, it's hard to say in advance, right? I think the specifics of any capital investment or O&M expenses and the specifics around any potential future outages are going to be what dictates the answer to that question. Of course, the company is going to do everything it can to keep the unit online and available like it does for all of its units. But we don't have a crystal ball, right? We don't know exactly what's going to work, what's not going to work, both at Comanche 3 as well as all the other units that now have performance incentives around them. So we're going to do the best we can to be prudent operators and prudent stewards of our customer dollars. But we know we're going to have to defend every dollar there, just like we have in the past.
Okay. You indicated in your rebuttal testimony when understandably the suggestion from staff in answer testimony was a different quantity than we're talking about in the settlement. But you had indicated that this approach with regard to the Unit 3 availability, PIM, generally would require an immediate write-off of the Pueblo 3 plant in service, as well as it would be considered an impairment. Can you walk me through what that means and if those are still concerns now under the settlement term?
Good question. So I'm not an accountant. I'll preface all this by saying that. But my understanding is, to have a write-off, right? It's essentially a question of, do we have confidence that we can recover the depreciation expense of the underlying asset? With the full revenue requirement in question, the answer to that is pretty clearly no, right? You're not just talking about the earnings component, you're talking about recovery of the underlying investment, the capital outlay to bring that unit online. And that's covered by the depreciation expense. And so, right, 30 million doesn't eat into that, right? The 30 million is of a magnitude whereby we're just talking about eliminating in a year, right? Just contemplating a scenario in which the unit was not available, we incurred a full $30 million penalty. Now we're talking about $0 of earnings on the unit, and we're eating well into the cost of debt associated with that revenue requirement. And so, right, that would require shareholders forking over additional dollars to cover that cost of debt, because as long as if you're paying your debt expense, that's a very good thing. If you're not, that means you're going bankrupt, and that's absolutely an outcome that we're avoiding at all costs. And so, that's the way to think about the kind of $100 million versus $30 million swing there to the settlement agreement. I think that it avoids the impairment, but does not avoid it based on some recommendations in answer testimony.
Okay, and can you define impairment for me? Because I feel like I'm conflating the write-off and impairment.
Yeah, I'm conflating those two. Maybe an accountant could tell you a different question. My understanding is that those are basically interchangeable. It's an impairment test on whether or not you have a write-off. So I've been using those interchangeably.
Okay, got it. And then you do say on page 44 of your rebuttal testimony that the unit, referring again to Pueblo Unit 3, ran during the majority of the 2025 test year. Do you know the percent of the 2025 test year that the unit ran?
So it was out from roughly mid-August through the end of the year. So that's going to be the last quarter plus.
Well, I will indicate we are aware there were other outages.
Oh, sorry. Are you talking
That's
about the
not
test
the only
year,
outage
Commissioner?
the plant had in 2025.
Oh, gotcha. Sorry if I misunderstood you. Are you talking about the history of the plant or just the test year?
2025 test year.
Yeah, so in 2025, it'll be, slightly more than that quarter. So a quarter and a half. So roughly a third, roughly 30%.
But again, that's just for the
33%.
outage that began in August.
Correct.
I'm telling you, I believe there were other outages of the plant in 2025. Are you aware of other outages?
Other unplanned outages? I'm not up to speed on those details. Mr. Hansen could tell you.
Okay. So you wouldn't have a percentage to allow us to understand what majority means.
For unplanned outages, I'm not sure what the total number is.
Okay. So also in your rebuttal, you talk about the past company responsibility for Pueblo Unit 3 outages, including $14.4 million for a 2020 outage, $11.6 million for a 2022 outage. And you say there that in response to the 2020 and 2022 outages, the company proposed customer refunds right out of the gate. Does that sound familiar?
Yes.
Okay. So I was curious with respect to the 2025 breakdown, has the company proposed any company responsibility for that breakdown or replacement power or its fixes right out of the gate in this circumstance?
Not right out of the gate on this current outage, but just noting that we'll have this the proposal is to have this new performance framework in place. The company's already committed to providing replacement power cost analysis in that standalone prudence review on the current outage, and so all that'll be reviewed at that time.
Okay, it will be litigated, but we don't have a similar scenario like in the 2020 and 2022 breakdowns where the company initially suggested company responsibility for some of the costs.
That's true. We haven't made a similar statement here. I'm still coming up to speed on the nature of the outage and the details around it, so we haven't made a similar commitment here.
Okay. And as for that filing, that shall file in June, by June 2027 per the settlement agreement, there seems some potential controversy over what's considered replacement power costs. We have some different parties suggesting that extension of Unit 2 is part of the replacement power cost. So I was curious if there are any understandings as to what is within or outside of the analysis of what is considered replacement power costs for that future prudence filing.
We didn't outline those specifics here in the settlement agreement, as I'm sure you're noting here. Of course, there's always the potential to confer with parties leading into that prudence review. To preview our approach to replacement power costs if other parties have different views. And of course, once you're into the actual prudence review itself, right, there's always a lot of requests that come at the company for different looks and pieces of analysis. So I would say it's probably a conversation most ripe for that prudence review as I stand here today.
Okay. And then changing subject. Staff witness Gabriel Xavier expressed concern that the company may be including vacant positions or vacancies on staff in the revenue requirement, as they did in the 2024 gas rate case. And I know the commission had directed in the company to remove them in that 2024 gas rate case. And I was curious, it seems as though the company has confirmed those vacancies are out of the revenue requirement. I just wanted to confirm that, since I didn't really see any explanation for that change in position or advocacy.
Yes, there's nothing in the settlement agreement itself that deals with the issue of vacant positions. The company continues to maintain that the costs in the test year for labor are actual incurred costs. If you have other questions around what's in or out of the test year, Mr. Freitas might be able to go in more depth there on compensation costs, but these are the actual incurred costs, subject to the additional removal of costs in the settlement agreement around AIP and LTI costs.
Okay. And would that be for staffing levels as they were at the end of 2025, given the use of the end of year values in the settlement agreement?
I don't think it's a end of year or average year rate based question. I think it's a snapshot in time of a full year, right? What were the total labor costs incurred during this test year as a representative look to future costs?
Okay. Are you confident in that, or should I check with Mr. Freitas?
Mr. Freitas could confirm, of course, that's my understanding.
Okay. And then I know there have been some concerns in the past over the company, especially cutting staffing related to customer service functions. There was a significant decline in 2023. And while the company, it looks like from some testimony, has increased some of the customer service staffing very recently toward the end of 2025, we certainly don't look to be at 2023 levels or pre-2023 levels. So I was curious how, this seems to be an ongoing concern, where the company has cut some of these positions or seen declines in staffing kind of after some of these rate cases, which sometimes results in concerns about customer service level that customers are getting. So I was curious, is this something that there could be a rational way to track instead of just assuming certain levels, whereby if the company cuts personnel after the rate case, that would be one-to-one tracked to ensure that that action does not result in additional company profit?
So just to clear up the company's actions here, right? In no way was it the company cutting positions after a rate case, right? Our customer billing, call center staff, customer support generally supports 8 states and 4 operating companies. And so I'm not aware of any decisions that were made in light of just one rate case in one particular state. I think the challenges we've described, both in this testimony as well as in, I think, a report about a year ago, acknowledging that we were slow to respond to this, was that exact fact that these trends happened coming out of the pandemic, that it was really hard to retain customer service professionals. We had a lot of attrition and we were slow to react, and the company takes full responsibility for that. We've righted the ship since there. We've gotten the staffing levels back up to where they need to be, as shown in our, not only the testimony in this case, but we have quarterly reporting on that metric and a bunch of other metrics to show how we're supporting our customers on billing and outages, and customer service, call centers in particular. So very much our hope to not see a similar trend happen again. But we think that was largely out of our control in terms of the impetus of that. But yes, we were slow to react. And now I think we're tracking it closer to make sure it doesn't happen again.
Thank you for that. I mean, I guess regardless of the reason why there was less staffing, and so that revenue then goes to the company's bottom line. If there's not staff, you're paying with it. The end result is maybe similar, depending who initiated that. The customer struggled with customer service and the company still retained the revenue. So I'm just wondering if a better tracking of actual personnel expenses would be appropriate.
Well, help me understand what you mean by better tracking of it. Beyond the quarterly reporting that we're providing on these headcounts, of course.
Yeah, like an actual tracker mechanism in rates, like how
Oh,
we
gotcha. Okay.
different
Yeah.
other changeable amounts.
Gotcha. Okay, thanks for clarifying. Yeah, that's one approach, right? I know we'll have an electric QSP coming forward again at some point over the next year or so. That could be a good forum to talk about this because we currently have in place a metric around customer complaints and telephone response time. And so it's captured in two existing metrics. If we wanted to add another one or change some of the structure of those, I think that's absolutely ripe for discussion. So that could be another approach as well.
Okay. And then am I correct that the environmental LTI or long-term incentive, employee incentive is proposed to be funded at 50% level in the settlement agreement in accordance with E36D? That kind of just seems to lump a few of those things together.
Yes, I think that's a fair understanding that the remaining LTI expense is the total amount less all of the earnings or performance-based amount, and you take all the remaining amounts and you divide it in half. So yes, for the environmental, for the safety, for the time-based, it's half of each of those.
Okay. And then just wanted to ask you quickly on the RISA issue with regard to EOC's recommendation to use some of the outstanding RISA balance to fund some targeted help. Help me understand kind of in translation from the RE proceeding and from the res proceeding, what is your anticipated view of how that RISA balance moves forward in terms of the cost of current programming and like how that's going to transpire roughly?
Roughly, my high-level understanding of it, not being a witness in that case, is that there is a large outstanding RISA balance as of the duration of that case. I know that we're several months into that case being resolved. I think that RISA, based on the outcome of that case, the RISA balance is declining over time based on the changes made in that case between costs flowing through the ECA directly versus the RISA. There used to be rebalancing that happens on the back end. Now it's a little cleaner and simpler. I think that change is going to drive reduction in the outstanding RISA balance. I'm not sure the exact time frame over which that balance gets to zero, but it's my understanding that in the coming years, that balance should decline significantly.
Okay, got it. I think those are my only questions, Chairman.
Thank you, Commissioner Gilman. Good afternoon, Mr. Pate.
Good to see you, Chair Blank.
Just a few preliminary questions and then 3 or 4 areas to talk about with you. Is it fair to say that the capital spending that you're asking us to place in the rate base in this case will get amortized over many decades, 40, 50, 60 years? Is that right?
Yes, generally, yes.
And is it accurate to say that the last electric rate case was decided in 2023 and was based on an end-of-year 2022 historic test year for rate base and O&M spending? Is that right?
Yes.
Okay. Under cost of service regulation in Colorado, is it fair to say that the company's earnings are directly linked to growth in capital spending and rate base? For example, and just roughly for every $1 billion in net rate base growth, the company's annual earnings grow, all else equal, by say 70 million at a 7% WACC, or 71.4 million at a 7.14% WACC. Is that link roughly accurate?
Yes. The company earns money by investing in infrastructure to provide safe and reliable service to customers. So we don't recover on those dollars until they flow through a base rate case like we have here or through a rider. But yes, I agree with the overall framing of them.
All right, just a quick thing on average residential rates. Can we pull up what has been marked as hearing exhibit 1502? And let's start on the first page. And let me represent to you that this is the Public Service Company of Colorado 10K from 2021. And do you see that I think right below the box with the check?
Yes, I see.
Okay. Can we go to page 5? And I just want to show that average residential revenue per kilowatt hour was 11.46 in 2020 and 12.46 in 21. Can you go to page 5?
This is page 5?
No, can you go to page 5?
Yeah, this is page 5.
Oh, can you scroll down 5 pages?
To page 10?
Yeah, I guess.
This is page 11. Should I keep going?
Oh, geez, I can't see it. It's frozen on my screen. Can you see it, Mr. Piquet?
I can see the screen, yeah, but the numbers are a little small.
I don't know. It's this is frozen on my screen. All I see is the first page.
Let me go back to page 5 then. What is it you're looking for again?
I can't see anything else other than the first page. I'm sorry. See if I can see it on my phone. Okay, there it is. Sorry, can you try page 5 of this?
This is
Okay,
page 5.
Okay. Jeez. Why don't we take a 5-minute break and see if I can get this straightened out? Come back at 2:30. Okay. Sorry. All right. Apologies. I had a frozen computer and the wrong exhibit number. I have bad dreams like this. Um, can you just scroll, expand the view? And do you see residential revenue per kilowatt hour of 12.46 in 2021 and 11.46 in 2020?
Could you scroll up slightly? I think it's right there. Yeah, so 11.46 and 12.46 and 11.46. Yep, I see that.
Thank you. You can take that down. Just a brief conversation on capital spending. I think this record is really clear on plan on service and rate-based growth, but less so on capital spending. Can we pull up hearing exhibit 1502? And I think this is the same exhibit we just had up and got confused. All right. Again, you see that's December 2021, Excel. Can you go to page 47? All right. Do you see capital expenditures? And do you see for Excel, it's 1.625 billion in 2021. Do you see that, Mr. Piquet?
I do, yes.
Okay. You can take this down. Can you pull up what has been marked as hearing exhibit 1503? And let me represent that this is the Excel 10K for the year 2025. And you see that 2025?
I do, yes.
And can you turn to page 53? And scroll down a little to the public service company line. Do you see the capital spending in 2025 for Public Service Company of Colorado was $5.440 billion? Would you accept that?
Yes, I see that.
And it's a projection, but do you see 2026 is almost $6 billion?
Yes, I see that.
Okay. And you can take this down. And I also have Excel Energy 10Ks for the calendar years 2022, 23, and 24 available on Mark. But subject to later check, would you accept that public service company's capital spending, at least according to the 10Ks, was 1.94 billion in 2022? That's on page 42 of that actual document. 2.31 billion in 23 and 3.18 billion in 2024. So subject to your attorneys making sure that's all right, would you accept that for now?
Yes, I don't have a basis to disagree with any of that.
Okay. So we agree that capital spending was 1.625 billion in 2021 and 5.44 billion in 2025. So the company's capital spending in Colorado has more than tripled in the 4 years from 2021 to 2025. And subject to later check, if I represented to you that this represents a compound annual growth rate of 35%, would you have any reason to doubt that?
No.
Okay. Can we pull up what has been marked as hearing exhibit 1515? And let me represent that this is taken directly from the link in hearing exhibit 600. It's Mr. Lerman's answer testimony at page 44, footnote 76. And let me represent to you that this is an Excel Energy investor presentation from March 2026. So if you can pull that up, Ms. Federico.
Yes, sorry, my computer froze too. I've got it.
Okay, thanks. So do you maybe scroll down a little? Go back. Do you recognize this as an Excel Energy investor presentation from March 2026?
Yes, that's what it says here.
Can you go to page 17? Do you see where Excel is committing to the financial community 6 to 8% earnings per share growth?
Yes.
And can we turn to page 11? Do you see where Excel is committing to the financial community that Public Service Company of Colorado will grow rate base by 7% from 25 to 2030? Do you see that?
Yes, I see that, and I'll note that that's far below the growth rates in some of our other jurisdictions, just for full context.
Fair enough. Fair enough. And if we could turn to page 25. And I think this was in Mr. Lammert's testimony, but do you see you're near the bottom of the peer group when it comes to non-fuel O&M spending? Is that fair?
Yes. Yeah, that's a fair characterization.
Okay, you can take this down. Can we pull up hearing exhibit 123, attachment JJP1, which is the long-term rate model attached to your supplemental direct testimony. And I want to go to the CapEx selection tab. And can you go to cell B3 where it says 7%? And can you change that to original? I think if you click on that, it'll give you a drop-down menu. Yeah. Perfect. And now can you go to the revenue requirement tab, line 32? And do you see how equity returns go from 872 million to 1.682 billion in 2030, which is column I, and you can scroll up so that he can see the dates. Yeah, do you see how equity returns increases from 872 to 1.682?
Yes, I see.
And let's go to the class allocation tab, K13. Yeah, thanks. And can we go to K13? 113, sorry, 113. And do you see how rates in 2030 are 21.81 cents a kilowatt hour? Is that right?
Yes, that's what it shows here.
Can we go back to the CapEx selection side? And can you put it on 7%? And now let's go to revenue requirement. And do you see how equity returns in 2030 are now 2.1 billion? So it's over $400 million higher. Do you see that?
In 2030, yes, I see that.
And that's it, just assuming capital spend grows at 7%, which is basically what it seems like the company is committing to the financial community in its earnings presentation. And just one more thing, and then I'll turn it back to you. Can you go to the class allocation side? And you see in 2030 rates are now 25.2 cents a kilowatt hour.
Yes, I see that.
So basically, by growing capital spending more quickly, by what you're saying, earnings are $400 million higher, but it comes at a significant cost to customers. Well, let me say it this way. I think we agreed that average residential rates at the beginning of 2021 were 11.27 cents per kilowatt hour. So we're more than doubling average residential rates from 2020 to 2030 if capital spending grows at 7%. And I think you've testified for the last 4 years, it's grown at 35%, subject to check. So I guess the question is, can you understand why this might raise affordability concerns? And any comments on this link between earnings, capital spending, and rates? So you can take this down.
A couple comments in there, and apologies if I'm not weaving it all together here, Chair Blank. But I'll just note from the outset that the 7% CapEx growth scenario that we just ended on, it is not tied to the company's current forecasts, right? So what the company shows in publicly available investor decks and in reporting through 10Ks and otherwise is consistent with that original or base scenario in my long-term rate forecast model. In my supplemental direct testimony, I go through some graphs and explanation for why that's not our capital plan. It is, yes, our capital growth or our capital investment has increased in recent years. We are not projecting for that same level of growth to continue in perpetuity.
But there's
a stark difference in those scenarios.
Didn't the investor presentation basically commit to 7% growth in rate base, even though it's not consistent with the capital forecast it presents? But I think that's what you're committing to investors is 7% year-over-year growth in rate base. I mean, that's what it says.
That's what that slide says, but it doesn't match the capital forecast. And I'll have to look at that closer to figure out what the discrepancy is. But I can 100% say that 7% growth scenario from our long-term rate forecast is not what we're projecting. It's not what we're planning for. It's not what we're managing to. It is the company's capital forecast. I think there's a slightly updated version. Oh, sorry.
No, go ahead. I apologize.
I was just going to say, I think there's a slightly updated version of the long-term rate forecast in the JTS proceeding that was submitted this spring. I think it's pretty similar to the original forecast shown in my supplemental direct. I'm not saying there's a need to pivot, but just wanted to show that, like, hey, in both models, we're not showing anything near that CapEx growth. And so that the increase in rates, I think, it's more important to focus on that original scenario that you pulled up. And in that original scenario,
which is still a big rate increase.
Well, it's in nominal dollars, yes, it's an increase from 2021, and it's an increase from where we are today. I think the important thing is to dissect that, right? What is going into that increased investment, which is then driving those nominal rate increases over time. And I kind of think about that in 4 big buckets. But we can chat about those more, of course. And I see that one as electrification, right? We're investing more in our generation, transmission, and distribution grids to be able to bring online new clean energy and to support the electrification of sectors that have used on other higher carbon emitting fuel sources, be that propane, gasoline, natural gas, or otherwise. So that's kind of bucket 1. Bucket 2 is steel for fuel, right? It's kind of part of that electrification piece, but different, right? We're making a lot of those big investments that explain the increase from 2021 to 2025 to where we are. A lot of that's from steel for fuel based on prior planning proceedings where we've said, yes, we want to invest more in renewable energy. We all think this is a good idea for carbon reasons and for cost-effective reasons too. Those were the most cost-effective resources on those solicitations a few years ago. And I still think they're cost-effective. I'm not saying we're trying to change course at all. The third reason is aging infrastructure. Sorry.
No, go ahead.
Should I keep going? Okay. The third reason is aging infrastructure, right? We've invested a lot in the grid in recent years because a lot of our assets were installed in the 50s, 60s, and 70s. We're coming up on what we've been describing as an investment cycle. The goal is that this doesn't continue forever, obviously, but we want to make sure that their assets in the ground are safe and reliable and that we can use them as long as appropriate, right? We want to get as much value out of these assets as we can, and that's in customers' benefit, of course. And then lastly, inflation, right? We haven't been immune to the broader cost pressures on the industry and certainly on the economy in general. So when you combine all those factors together, yes, there are nominal dollar increases in the rate. When you control for inflation, I had I think what was a helpful graph in my rebuttal testimony on this fact, showing when you control for prices, I think it's on page 12 or so, our rates have largely stayed flat. There's been a slight increase over the past year or two. Again, some of these trends combining to push rates above the rate of inflation. but rates are largely stable.
Is it possible that part of that is the extended amortization where you can increase capital spending at 35% a year, but it doesn't increase rates in the near term that much? Is that one possible factor that could be accounting for the slow increase in current rates?
Well, right. That's a natural part of rate making, right? That we take the revenue requirement based on all these assets, and luckily these things have a really long life. So that's great. We can spread those costs out over a long period of time. That helps customers. Absolutely.
Both Mr. Skluzak in his answer testimony at pages 41 and 42, and Mr. Larman in his settlement testimony, page 6, raised concerns about capital bias driving the company's capital spending levels. Likewise, in our GIP and DSP orders, we expressed significant similar concerns. Any comments on this concern in this case and elsewhere? The capital bias, for example, the $400 million in extra equity returns you get from growing capital spending at 7%, is one factor leading to the large increases in the company's capital spending.
So it's a true statement, right, that the regulatory compact allows the company to grow its business and earn more dollars by building infrastructure, right? That's the core of our business. I would challenge the notion that we're investing too much, right? If anything, one could argue the opposite. Every single dollar that we invest, every large project gets reviewed internally and externally here in this proceeding and in others. And so we're really mindful of every customer dollar. The other important piece to remember is that, besides a couple limited issues in this proceeding where folks are taking issue with some of the legacy meter costs, some of the transmission project costs, people are not saying, hey, what we did here, what we invested in wasn't needed. People recognize the interveners recognize the need to invest in AGIS and new meters, right? We're kind of going back, and there's a little bit of a revisionist history on what got us to that decision and the costs entailed with that transition. And we reached a settlement agreement to address both of those issues here. It was a good landing zone for all the parties, and we're all recognizing our differences of opinions as a starting place. So beyond those two buckets of costs, and thinking about the investments at issue in this case, folks are not saying, hey, you shouldn't have done that.
Can we pull up hearing exhibit 104, attachment AEB-10, tab 2? And let me represent to you that this is a slide showing the ratio of 2025 to 2030 capital expenditures as the numerator divided by 2024 net plant for a proxy group of utilities. It's attached to Ms. Bulkley's testimony.
I'm sorry, sir, it's just going to take me a second to pull up the executable one. AEB 10, you said, right?
Yeah.
Sorry, Chair, could you repeat? Was it AEB 10?
Yes.
Thank you.
Hearing exhibit 104. And I think what you'll see is that public service company, in terms of that capital spending ratio, is the most aggressive utility in the peer group in growing capital spending as against the 2024 net plant.
I think that exhibit's being pulled up, but if I can just talk about it at a high level,
please.
If that's okay, Chair Blank.
Yeah.
Okay. So the broad characterization that we're on the higher end of the proxy group in terms of equity ratio, I think is correct. Ms. Bulkley can talk more details there.
Can you hit CAPA the second one? Yeah, there's the graph, and maybe you can get it in on it. You can see public service company is on the extreme right, way above its peer utilities in terms of capital spending as a percent of 2024 plant. So with that, go ahead.
Great.
Sorry.
No, thanks for clarifying it, and thanks, Ms. Federico. The important context here, and Mr. Wayner's testimony talks about this too, is there's a reason behind this. It is to maintain our capital, our credit metrics in a financially efficient way. And the equity ratio is a great way to do that for customers' benefit, instead of having higher cash flow or higher ROEs otherwise. And the reason why we need to keep this more elevated compared to the proxy group largely stems from our resource acquisition decisions. Those are in proceedings that I'm usually not a witness in, so I can't go too in depth there. But I know that company ownership is of a certain share. When it's not company ownership of a resource, it's a PPA or some other company building and owning that. Our rating agencies consider that as debt. And so we're no longer splitting that between a debt and equity investment, in which case a 50-50 equity ratio to debt would make sense. If that's treated as debt, we've got to compensate for that on other portions of our capital structure. And so that's why you see a ratio here that's compensating for that exact fact. And so to maintain the credit metrics that we have, that's what's driving this, along with those resource planning decisions. If we were to own a little bit more of those portfolios, maybe there's a world where that comes down a little bit. But I think based on where we are today and maintaining the credit metrics we have, which I think is in everyone's interest to keep costs low for customers, we've got to have a higher equity ratio.
So just to be clear, this is not a capital structure graph. This is just projected capital spending from 2026 to 2030 divided by 2024 net plan. So it has nothing to do with capital structure.
Gotcha.
This is just showing that the capital spending of public service company compared to 2024 existing plan is significantly higher than any of its peer group. And that includes, D, which is Dominion, which has, very large data center growth. It includes, I think, SO, which is Southern Company, which has just put a giant nuclear plant in rate base. So even compared to your peers, which are experiencing, growing revenue, doing all kinds of stuff, you're with still basically relatively small sales, or comparatively spending more capital compared to the existing base, compared to your peer groups. So I'm asking you about the level of capital spending, not the capital structure.
I'm sorry for that. I was providing hopefully a good answer to a question that was not
Different
asked.
question.
So that's my mistake. Apologies. So on the capital expenditure side, I would say, without digging into the details of every company here, the goals of the company and the goals of Colorado must be driving this. That we're trying to be leaders in the industry and leaders in the world on driving carbon reduction in cost-effective ways. We're making targeted investments to achieve that, and those investments, absent those couple examples I talked about before on some legacy meter costs and a few cost increases on transmission projects compared to what we originally estimated them at, folks are not taking issue with the investments in this case. So I agree, right? Based on the data you're showing here, or that Ms. Bulkley has shown, that we're spending more on CapEx than others are. And the question is, what are we getting for that? Is that good or is that bad? Can't be answered just by looking at the cost. We've got to think about what are we getting. And we're getting carbon reduction, we're getting new customers, we're getting economic development, and all the stuff that we want, that I would think we'd want as policymakers.
You testified that the company's capital spending was amortized over many decades. Well, actually, can you go to the first tab? And can you scroll down to the public service one? Okay. Do you know if the capital spending includes the NTP in it or not? You mentioned that the company's capital spending plan was firm and not going to grow rate base by 7%. Do you know if the NTP is included in that original capital spending plan?
Good question, Chair Blank. I don't think it's included in my long-term rate forecast, since I think the basis for that was from a year prior. I think the capital forecast earlier in the JTS process. I think the forecast included in a parallel proceeding this spring into the JTS itself incorporates more of those assumptions. To bring those closer in line to where we stand today.
So if we added the NTP spending, and I think we approved a $1 billion plus wind farm, that would move the original capital forecast closer to the 7% one. Is that fair?
Well, I was answering from the perspective of my long-term rate forecast to show how this changes over time. In terms of Ms. Bulkley's attachment here, I would assume she's pulling the latest available, so this might include the NTP.
All right. But, all right. You testified that the company's capital spending was amortized over many decades. Can you help me better understand why current wallet share is a relevant metric for investments that pancake in the rates over 40, 50, 60 years?
Electric wallet share is a helpful metric in our view because it sets a common metric to evaluate different utilities and states. So it compares our costs to what share of budget someone's paying for, right? A median income, right? Average bill compared to median income in a state or a certain geographic area compared to other areas. And right, it's not just our data that shows, I think as my supplemental direct testimony and rebuttal testimony talk about, right? There's other studies out there from Charles River and move.org showing that Colorado's costs are super low for utilities compared as a percent of household income. That's great. That means we're doing a good job as a utility and as a broader regulatory environment here, certainly the commission included. And the state is doing a good job on economic development because we have higher than average wages. So both of that shows that compared to other states, utility costs are very affordable in Colorado. Of course, everyone wants to minimize their bill as much as possible, and we're working hard to keep costs low.
All right, you can take this down, but would you agree it's just a current snapshot in time, and it doesn't say much about how investments pancake into rates over 5, 10, 15, 20 years, given these 50-year amortization schedules?
Well, we can certainly project wallet share. I think we might have projected a year out, but it entails our rate projections being combined with income projections for the state. So absolutely doable.
Okay, you can take this down, Ms. Federico. You talked about a number of different buckets for capital investment, CPP, electrification, and is it fair to say both those type of investments either grow revenues or reduce costs? Is that a fair characterization of those two buckets?
Yes, I believe so. The goal is to connect more clean energy and have encourage customers to use more of that clean energy to displace carbon elsewhere in the economy. So yes, I believe most of the investment is revenue producing, if that's your question, Chair Black.
Yeah, for purposes of this conversation, just focus on the economic benefit. So it seems like if we're saving fuel or growing revenues on EVs, that helps put downward pressure on rates.
Absolutely.
And we've allowed TCA recovery for transmission expansion, and we've allowed GMAC recovery for distribution investments that say increase revenues or interconnect new customers. Is that generally fair?
Yes, in those two buckets of investment in particular, yes.
And I guess for ordinary course transmission and just distribution, what you called replacement, is it fair to say they're generally or often not eligible for accelerated cost recovery through the TCA or the GMAC? Is that an accurate characterization?
Generally, yes. Right. Our transmission investments that don't increase capacity are not permitted to flow through the TCA, and same for distribution investments. So asset health and reliability on the distribution side does not currently flow through the GMAC.
All right. And in the wildfire mitigation proceeding for spending that helped reduce wildfire risks but didn't really lower customer rates or costs, the company proposed and the PUC agreed to securitize capital spending. Is that right?
Yes.
Any thoughts about this commission providing more attractive cost recovery as sort of a general policy for, call it, economically productive investments like steel for fuel or beneficial electrification that help lower costs or increase revenues and put downward pressure on customer rates, and at the same time perhaps providing less attractive cost recovery for ordinary course investments that do not help lower customer rates?
So that seems like the paradigm we're in based on what we were just discussing. I think my comments on that paradigm would be, it seems like we're inherently then valuing asset health and reliability investments that are not adding capacity, but are still really important, or valuing them less from a regulatory perspective. The company does not have the same incentives, financial incentives to pursue them as aggressively. I don't think that makes as much sense as to think about what provides the most value to customers in the system. I would expand those buckets in light of those asset health and reliability benefits. But that's the regime we're in today. I'd agree.
Okay. Last topic, O&M. And I know you talked about Commissioner Gilman and with Ms. Van Giem. And in your rebuttal testimony, pages 23 to 31, you respond to a variety of concerns about customer service, reliability, unit performance. In his answer testimony at page 46 and in a settlement testimony, Mr. Lerman argues that the company's inability to earn a return on O&M may at least partially explain why the company proposes a significant increase in capital expenditures on which it earns a return and much less investment on O&M. And the peer group data you and I just discussed shows that the company is near the bottom of O&M spending and at the very top of capital spending. So this data does seem roughly consistent with a hypothesis that the company may be aggressively responding to, regulatory incentives, potentially misaligned regulatory incentives. Thoughts, comments on that hypothesis?
I wouldn't describe it as misaligned regulatory incentives. I would say, looking at those two graphs in particular, right? The company is really efficient at providing safe and reliable service to customers, right? We're expanding our systems to support state policy goals, and we're doing so at a relatively low cost compared to our peers. That's great. That's something that everyone should support. Are there spaces to think about where we should be spending more in? Absolutely. We can have that conversation. It's cases like this, right? Base rate cases, other cost recovery conversations that set our budget moving forward, right? What can we accommodate from an investment perspective before we need another rate case? What can we accommodate on O&M levels? And so these are all tied up in a proceeding like this. And I think the settlement agreement provides a really good landing place on how to balance this moving forward, right? It can let us support these investments moving forward that do not have rider recovery at reasonable O&M levels, right? The staffing and support services we need to effectuate it. But I don't think we should be contemplating rejiggering the regulatory compact to try to drive less earnings, but more O&M spending, right? It all comes from proceedings like this, that with a bigger budget, we can do more, right? We can hire more people to do more great work and continue to be efficient about it.
Can we pull up what has been marked as hearing exhibit 1507? And let me represent that this is the 2025 Piesco 10K. And if we can turn to PDF page 31, and this is non-fuel O&M expenses that shows spending of $865 million in 23, $926 million in 24, and $977 million in 2025. Do you see that? It's like the fourth line down under our operating expenses.
Operation and maintenance expenses. Yes, I see it now. Thanks for connecting.
Yeah. So it goes 865 and 23, 926 and 24, and 977 and 25. Is that right?
Yes, I see that.
And would you agree, since 2023, you've increased O&M spending by $112 million? Is that right?
Yes, that's what the data shows here.
Okay. You can take this down. Can we pull up what has been marked as hearing exhibit 1508? And this is the Piesco 10K from 2024. And if you can go to page 32, this will show, and I think this is exactly on Commissioner Gilman's point, that you cut O&M spending. Let's see. Do you see O&M spending 22, 23, 24?
Looks like it went up, but there was a decline in 2023.
Right. So, and do you see that
So
decline was $40 million?
yes. And then it
Okay.
went back up to be higher than the level in 2022 and 2024. So,
Okay.
so something interesting was happening in 2023. You know, some of those trends we saw in customer care might have been happening in other parts of the business, but I can't quite speak to all those details here in the moment.
So you testified that 2022 was the historical test year in the last rate case. So in 2023, the company had $905 million of O&M, however, it got through in the rates. And if the company only spent $865 on O&M in 2023, then the company increased its pre-tax earnings, all else equal, by $40 million in 2023. Is that correct? Would you agree with that characterization? Or said another way, the $40 million in O&M cost cuts in 2023 all accrue to the company between rate cases. Is that right?
Well, it's hard to know what else is happening, right? There could have been significant increases in capital outlays to address a particular problem or challenges or goals we were trying to achieve in other parts of the company's electric system or gas system, since this is consolidated. So it's hard to say in totality what's going on here without more details underlying these numbers. You know, in isolation, right, assuming all else didn't change, a statement like that is correct, that 40 million would be an increase to the company, but we all know in reality all else is not equal, right? So there's a lot going on in any given year, and I'm pretty confident that 40 million was not on a one-for-one basis passed through to the company earnings as a result of this. I'm sure there was more going on.
Okay. Can we pull up here exhibit 1517? And this is, and go to page 13. This is, a staff presentation in docket 23, in docket 24I-0394E. And you can see this is the history of public service company penalties under the QSP, where it was relatively small in 2021, 2022, 2023, and then increased by a factor of 4 in 2024. Do you see that?
Yes, yes, I see that.
Okay.
That's largely, oh, sorry, I'm sure you had a question on me.
No, go ahead.
I'll just note that the structure of the underlying QSP changed at this exact same time. So it's not apples to apples to just compare the years to one another. We settled an electric QSP plan in the first half of 2024, which applied to the full calendar year of 2024 performance. And it added several new metrics and changed the way we think about some of our electric reliability customer credits. And so it was a combination of those two pieces of 2024 being an exceptional year from a weather and storm perspective, combined with kind of a changing underlying QSP structure to drive that change.
And would weather impact your customer call response time, which I think got worse by a fairly large amount? Is it fair to say that would be not dependent on weather?
Actually, I think that really is dependent on weather, actually, because when people lose electric service, they don't lose gas service basically ever, but when they lose electric service because a tree falls on a line, that's usually because the wind's blowing real hard or there's hail or other weather events going on. They tend to call the company to get information on outage restoration, on what's going on, or other questions that they have.
Well, let me ask it this way. In 2023, the company got up to 40 million in pre-tax earnings bump. Again, all other things may not be equal, but the QSP has a maximum penalty that probably is around 10 million, and you can see it only had 6.5 million in actual penalties. It just seems like the QSP may be too small to really set proper incentives. Any comments on that?
I'm trying to think of the total magnitude. I think that there's a cap of about 11 to 12 million dollars
Exactly.
in total
Exactly.
penalties here. That might just be on the reliability side. I don't know if that's all inclusive.
I think it's all inclusive.
Okay, yeah, happy to accept that then. In terms of whether that's a lot or a little, that's a fair question. I think we can explore that in the next QSP, and that's an interesting comparison to make in light of the Comanche 3 performance framework at issue here, right? That's going to be 3x that amount just for one asset, one metric.
Here's my it seems like a profit maximizing strategy for the company. I'm not saying you'll do it, maybe to cut O&M in 2026, right after the 2025 historic test year in this case is set, which would boost pre-tax earnings. And, to the extent there's modest QSP penalties, they wouldn't rise to anything close to a $40 million cut. Any comments on that fear?
I think that kind of presupposes the concept that the company doesn't care about electric reliability or quality of customer telephone response or the number of complaints, right? We care about all of that. We have an intrinsic duty to provide the best service at the lowest price to our customers. And we think we've done a good job. Of course, there have been challenging years at times. 2024 was one of them, in particular from the weather perspective, which drove some of this, which we're talking about here. But the company cares very much, right? Our employees are part of our communities, as are all the company's leaders. And so we know that we've got skin in the game in everything we do. We've got skin in the game when we come in front of you and other regulators across all states. So we've got to back up everything we do. And again, I'm not hearing issues from the other interveners in this party that what we were doing, what we were investing in, we shouldn't have been investing in. If not, they're saying they want, better results at lower costs, but better results come with a cost. And so we've got to find that appropriate landing spot. We think we do a good job finding that balance. If we need to spend more in certain areas, then we can certainly talk about that. that has budget implications at the same time.
Given that the company has righted the ship, would the company agree to, in this case, to quadruple the QSP caps to get closer to sort of offset the incentives to cut O&M? Or would, if the company does cut O&M, would it share some of the cost savings with customers? I think you testified how much O&M savings could benefit customers. If you cut O&M in 26, will you share that with customers?
I can't commit here and now to increasing the QSP metrics or penalties, right? There's also been a long going discussion on making this more symmetric at the same time. But I think you're raising a question of performance rates, I think, at its core, Chair Blank, right? How do we think about what we're all targeting moving forward, and what is the cost of that service? Should we set rates on a forward-looking basis so we get aligned on this more before things come at us in a historical perspective? Or do we need a broader set of metrics to align around what we're pushing towards, right? Be that emissions or cost or reliability or some combination therein. I think that's the conversation, rather than taking one discrete part of our budget or part of our work and saying, hey, we're going to track this closely, and anything dips gets refunded. Then we'd want something on the other side to say, hey, if we end up investing more because we have more needs, or we need to hit state goals faster, or it makes sense to do a particular project that's new or bring it up in time, then how do we capture the cost of that at the same time?
But you would agree that when you cut O&M in the year following a rate case, that is not shared with customers, and it's asymmetric to the customers. In 2023, it looked like it was a $40 million benefit. So comments on that?
Yeah, I think my one comment would be, just as in other years that you were showing, there were significant O&M increases between years, and there's not a mechanism where the company recouped that, right? And so in any particular year, could there be a decrease? Yes, you showed an instance in which that happened. I think the general trend over time is that O&M is increasing, just as our capital expenditures are increasing too. Not saying they're at the same rates, of course, because we try to get more and more efficient, but they're both increasing.
That's all I had. You can pull this down. You want to take a quick break till say 3:25 and reconvene with redirect? Would that work for you, Mr. Zomer, or do you need a little more time?
Could we have just a little more time? Mr. Piquet has been up for 2 straight hours, and
Fair
maybe
enough.
the court order may want a little time too.
Yeah, let's break till 3:30. Thank you.
Thank you, Chair.
All right, we're back on the record, and I guess Ms. Federico, if you could just make sure the parties have access to all the documents we discussed, but I'm not going to move them into evidence. I think the oral testimony is enough. So that, oh, Ms. Federico.
I was just going to say they're all in the shared hearing folder, so everyone has access to them.
Okay, cool. Mr. Zimmer?
Thank you, Chair Blank. Good afternoon, Mr. Piquet.
Hey, good afternoon.
All right, I'd like to start with something a little earlier in the day. You had a discussion with Boulder attorney Ms. Van Giem regarding O&M changes from second supplemental direct testimony to the settlement revenue requirement. Do you recall that?
Yes, it was 26 million-ish, 40 million-ish. Yeah, depending on where you're starting. Yeah.
So just to clarify, your discussion talked about the settlement revenue requirement study, APF 29, and APF 20, which was the second supplemental direct revenue requirement study. And that identified about a $41 million difference. Is that consistent with your understanding?
Yes, that is.
Can you describe what are the kind of drivers of that change?
Yes, so the settlement agreement makes a few modifications to O&M expense, but largely what it's doing is shifting a good portion of the conversation into another forum, right? So about 20 to 25 million of that is going to come from the reduction in O&M expenses from the wildfire organization. And so that's 100% of labor costs and 50% of non-labor are being moved to the WMA to be discussed and reviewed in those other settings. So that's a good chunk of it. There's also a couple labor cost tweaks that were made. There was a second year of merit increases included that we backed out 1 year of. There's the settlement agreements changes to the 15% AIP cap and splitting of LTI incentives. And the final change was the excess liability insurance premiums. I believe there was a $10 or $11 million error in the company's case, which we fixed. And so when you add those all up, you get to that $40 million. So it's not really a characterization of reducing O&M and a lot of that. It's just a couple targeted labor tweaks at the end of the day.
Okay. And just to clarify, the movement of the costs out of base rates and into the WMA still provides for recovery of those costs. Is that correct?
Yes, the company will seek to recover those costs through the WMA and work with stakeholders on the review of those costs.
And those are all historical costs that were incurred in 2025?
That's correct.
Ms. Federico, if you could pull up, and I may ask Chair Blank for a hand here. I had the PSCO 2024 10K as hearing exhibit 1507. Is that correct?
No, the PSCO 2024 10K is 1508. I'll pull that up.
Thank you. And could we go back to page 32? This is the table you discussed with Chair Blank. Do you recall that?
Yes, we were looking at the O&M line there in the middle.
Do you see the operating revenue line there?
Yes, at the top, I see that.
And is it correct that operating revenues decreased between 2022 and 2023?
Yes, those revenues went down by almost $200 million.
And that's more than the $40 million change in O&M expense?
That's well above that $40 million, yes.
Okay. Part of the discussion too was different mechanisms that could be used to align these sort of changes. Do you recall that?
Yes.
Would use of forward-looking rate making, like a future test year, have some of that alignment?
Yes, yes, it would. The company's proposed just that in past cases, but we've worked to align closer with the commission and other parties' views in base rate cases, and so we've moved away from that in recent years, but happy to have the conversation.
And so would formula rates?
Yes.
Okay. Could we bring up hearing exhibit 156, which is Mr. Piquet's settlement testimony? And can we go to page 8? And just so folks are seeing, this is the Rev 1 that was put in this afternoon, having that correction there. Your discussion with Chair Blank talked about investment cycle beginning in 2021. Do you recall that?
Yes.
And what has happened to the wallet share for public service since 2021?
It stayed largely steady, right? It increased in 1 year, but looks like it's slightly lower today than what it was in 2021. But for all intents and purposes, it stayed largely flat. You can see in the 2026 column off to the far right, the red bar, which is public service company, would increase based on the base rate change proposed in this proceeding and in the settlement agreement specifically. In presenting this view, I've kept the other two categories flat, right? Let's just assume the same level from other Colorado utility providers, and assume the same level nationally across utilities, just for points of comparison. Our expectation is that both of those levels will increase as everyone's making continued investments. There are lots of outstanding rate cases across the country, as we've talked about in direct and rebuttal testimony in this case. But just for a point of comparison, we just kept it flat. And the company would continue to have a much lower electric share of wallet than the industry in general, and we're really proud of that.
Part of the discussion too was that wallet share is a little bit of a snapshot in time. Do you recall that?
Yes.
What's your interpretation? Sorry.
Yeah, thanks, Mr. Zomer. This shows the 12-year history here, going back to 2014. And so not only just the period we were mostly discussing back in my conversation with all the commissioners over the past 5 years mostly, but you go back even further, you can see a downward trend over time. We've stayed really consistent in keeping rates low and as affordable as possible for as many customers as possible. Of course, we've got additional proposals in this proceeding through energy assistance to make our rates and service even more affordable for energy burdened customers. But seen generally here, we're the best in the industry.
Ms. Frederico, could you pull up hearing exhibit 133? And go to page 17. Mr. Piquet, you had a discussion with Chair Blank about the long-term rate forecast model. Do you recall that?
Yes, I do.
Is it your understanding that the rates in that model are in nominal dollars?
Yes, they are. And I believe as part of that discussion, I noted that rates have largely been steady in real dollars over the past decade. I think I referenced a graph in my rebuttal testimony, and this is that exact graph. I noted that there has been an increase over the past year or two. These are some of the inflation trends, investment trends coming on our electric generation, transmission, and distribution systems kind of coming to a head here as we try to build this system for the future. But you can see the general trend here being pretty steady rates when you control for inflation.
Ms. Frederico, could you pull up hearing exhibit 1515? And can we go to page 17? Nope, sorry. Looking for the O&M chart.
I don't know which page that was.
Yeah, I've got it. Just a second. Sorry.
Hold on, I can find it too.
I found it. It's 25. Mr. Piquet, you had a discussion of this chart with Chair Blank and with Ms. Van Geem. Do you recall that?
Yes.
Is it your understanding that that Xcel Energy number there is public service only?
No, this is Xcel Energy in total. I'm not aware of the exact breakdown across the opcos, assuming, right, we're all kind of slightly above or slightly below that average number, but that's an Xcel Energy consolidated number, as far as I'm aware.
Thank you. We can take that down. You also had a discussion with Chair Blank regarding calculating earnings based on the WACC and rate base. Do you recall that?
Yes.
When you're doing that calculation, is that only equity return?
No, that also incorporates the share of debt in the capital structure and the cost of debt.
And does that account for regulatory lag that may occur?
I think in that quick example, it did not. We're kind of assuming a revenue requirement of some asset or investment being recovered in real time. Of course, regulatory lag will decrease that over time, particularly as that lag increases.
You also had a discussion with Chair Blank about the long-term rate forecast model. You recall that?
Yes.
And does the long-term rate forecast model use the same sort of calculation that doesn't account for regulatory lag?
It does. It assumes essentially an immediate revenue requirement based on it assumes capital expenditures basically equivalent to cap adds. It then calculates a real-time revenue requirement based on that, of course, making assumptions around O&M and depreciation and all of that. So it's real time. It doesn't incorporate regulatory lag. So it's a little bit of an apples to oranges when you look at the historical rates and then you kind of merge into the forecasts, given that different treatment.
Okay, changing topics. You also had a discussion with Commissioner Gilman regarding long-term incentive costs that were excluded from the settlement test year. You recall that?
Yes.
Is that an adjustment for rate-making purposes?
Yes, that is an adjustment for rate-making purposes. You know, the company will continue to pay the salaries and benefits that it deems appropriate to attract the right talent that we need in this industry. We try to keep really close to those markets and attracting and retaining the best people we can, and so that the company's gonna do what it needs to accomplish that.
Ms. Frederico, I'm sorry to be bouncing around. Could we go back to hearing Exhibit 155, the settlement agreement? And can we go to page 14? Mr. Piquet, could you just kind of get yourself familiar with paragraph 23 here?
Okay, yeah, this is addressing year-end rate base.
And the test year and the capital additions that are included therein?
Yeah.
Okay. And you had a lot of discussion, Commissioners Plant and Gilman and Mr. Gerhardt regarding future investments for Comanche 3. Do you recall that?
Yes.
Based on your review of this paragraph, are those future investments included in the test year revenue requirement?
No, certainly not future investments that are unknown based on where we stand here today in light of a performance framework for Comanche Unit 3 being in place. And also the current investments or costs incurred for the current outage are also not included as part of the test year. Those would be capital additions at issue in a future rate case, if there were any, of course.
And those future capital additions would be reviewed for prudence as part of a future rate case? Is that your understanding?
Yes. Yes, they would. They're not at issue here in this case.
Okay, one more. I'm going way back to the beginning of the day, so I'm testing your memory here. You had a discussion with Mr. Bunker regarding sale proceeds associated with mineral rights. Do you recall that?
I do.
What's your understanding of the mineral rights that were sold?
Oh, my understanding of the mineral rights is those are associated with subsurface rights on property that the company owns. I think they were largely associated with property around the Fort St. Vrain generating facility, but I don't think they're exclusively around that property. I might have described it as, or Mr. Bunker might have described it as the Fort St. Vrain mineral rights solely, but it's broader than that. The company sold those subsurface rights for all of its producing wells as it stood at the end of last year.
Thank you. Let me check my notes. I believe that's it. Thank you very much, Mr. Piquet.
You
Thank
can
you.
be excused, Mr. Piquet. Thanks for joining us. Would you like to call your next witness?
Yes, I will do that, and then we're going to do a role change here. So I'll call, the company calls Ms. Deidre Howard.
Trying to get my video working here. One moment. There we go.
Oh, there you are. Ms. Howard, can you hold up your right hand? You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Put your hand down. Is anybody with you or communicating with you in any way?
No, sir.
If that changes, will you let us know?
I will do so.
Thanks. Back to you, Ms. Smart Pacheco.
Thank you. Good afternoon, Ms. Howard.
Good afternoon.
Can you please state and spell your name for the record?
It's Deidre Howard. That's Diedra, last name Howard.
By whom are you employed and in what capacity?
Xcel Energy Services Incorporated. I am a director of customer policy and regulatory compliance.
Did you cause to be filed in this case hearing Exhibit 107, Rev. 1, your direct testimony, hearing Exhibit 128, your supplemental direct testimony, and hearing Exhibit 139, your rebuttal testimony?
I did.
And I don't believe you have any corrections today to these pieces of testimony, is that right?
That's correct.
As they have already been admitted as hearing exhibits, Ms. Howard is available for commissioner questions.
Commissioner Plant, any questions for Ms. Howard?
Thank you. Good afternoon, Ms. Howard.
Good afternoon, Commissioner Plant.
I just have a couple quick questions regarding the company's proposal for the EAP program. One of the elements, I believe, is reducing maximum energy burden from 3 to 1.5% for electric and 3 to 1% for gas, for a total of 2.5%. So I was just trying to figure out how this works exactly. For those receiving electric and gas, the combined burden would be 2.5%, correct?
Yes.
And if you were only receiving electric, it'd be 1.5%
That's correct.
of the electric bill. And if you're above the threshold for gas, if a customer is above the threshold for gas but below the threshold for electric, would they qualify for PIP on their electric bill?
They would.
Okay, so it's a combined calculation. Thank you for that. Staff witness Anstey pointed out that of the 4 different methodologies in the Energy and Security Working Group report for calculating the number of eligible customers, the company decided not to use any of those. Why did the company decide on a different method?
I would say that there's a number of ways, and I think we've talked about it in testimony. There's a number of ways to look at energy burden. And what we landed on was wallet share, and using that as the foundation for, where we think this percentage should be, especially for our electric customers.
Okay. And that's the combined 2.5%.
Correct.
Regarding, this was also mentioned in Ms. Anstey's testimony, the third-party auditing of the self-attestation program. Ms. Anstey mentioned that California's similar program only unenrolled 2.3% of the enrollees. Does that sound right to you?
I don't have it in front of me, but I have no reason to doubt that
I
estimate.
was wondering if you've done any sort of cost effectiveness calculation. For example, if it's unenrolling 2.3% of the enrollees, what's a cost of that auditing? Like, are we spending way too much on auditing for the expected benefit of unenrolling? Or is there a certain percentage that you've calculated below which it's just not worth it to do the auditing program?
We haven't actually looked at that specific metric, but we are looking at a bunch of new ones, trying to model exactly what we think we're going to see. I would expect that when you lower this percentage from an average of 6 to 2.5, that we're going to see fewer customers not qualifying and therefore being able to stay enrolled. I think that's something that we'll probably need to look at here in the near term.
Yeah. Well, I mean, I guess what I'm saying is, how do we figure out whether or not the audit itself is worth it? If for example, it just unenrolls 1%, but it costs millions of dollars, is it really worth it to do it?
I think we're going to know that pretty soon, actually. I think if we're running this and, after this first year, we're doing that audit process, we're going to find out exactly what it's going to cost us. I know that, we're looking at what that third-party option might be for making that verification happen.
Right.
And then the number of customers that, like it's a percentage, 5% as Ms. Anstey recommended. We looked at 10% as a potential possibility as well.
Yeah. Great. Thank you. That's all the questions I have.
Commissioner Gilman, questions for Ms. Howard?
Thanks. I don't have any questions.
Thank you. Good afternoon, Ms. Howard.
Good afternoon, Chair Blank.
Is it fair to say that lowering the energy burden threshold from 6% to 2.5% increases the estimated population eligible for bill assistance, energy affordability program benefits to roughly 450,000 residential customers? And I think today's levels may be 250. And I'm getting that from Ms. Anstey's testimony, page 18 and attachment 2. Does that sound right to you, or would you say that differently?
One of the things that I tried to address in supplemental testimony and rebuttal was the fact that we have a lot of ways to estimate this customer base. And I think what we really want to do now is move past that and say, what do we really know? If we lower this percentage and more customers will qualify, we know that. But what does that really look like? And I think that's one of the things that we really want to see is what happens this next year when we roll this out and we're doing self-attestation and categorical eligibility and some of these other things, and then holding disconnections. Like, what do all of those measures put together due to this population? Does it take
All
some
right.
people out of it?
So there's uncertainty, but it's hundreds of thousands, whether it's 250, 300, 450, it's unclear. But it's a lot of people. And the change expands the universe.
It does.
Okay. And I guess you used a roughly 25% participation assumption, which implies, a quarter of that large number would be participating. If you use 450, it's 100,000 customers. If you use a lower number, I guess it's a little lower. Is that fair, or would you say that differently?
No, I would say that's fair.
Okay. And it sounds like the average participant received, I'm sorry, the median participant received an average yearly benefit, including arrearage forgiveness of $800. Would you accept that? I think that also comes from Ms. Anstey's testimony.
Again, I don't have the most recent report that we filed in front of me, but it's certainly possible that's accurate.
Okay. So providing support to whatever the number is, 80, 90, 100,000 customers at that level would require, I don't know, 70, 80, $90 million a year, which will certainly strain the resources given current spending. Is that fair?
I don't know if it's going to expend everything. Again, I think it's going to take some time in terms of outreach and education to make sure that we're getting, the appropriate customers enrolled. I know it's going to expand the audience. There's a lot of variables in there, like, how much arrears are customers going to be having that are maybe coming back to the program. I think there's a lot of variables that might affect that number.
Okay. And I think you're saying the company would like to hire 4 additional full-time staff to help with the education and outreach. And I think that comes from your direct testimony, page 57. Is that right?
Yeah.
Okay.
Yes.
Can we pull up hearing exhibit 1509? And let me represent to you that this is a March 2024 final report from the Colorado Energy Office entitled Evaluation of the PIP. And if we can turn to page 138. Well, let's get the first page up. Do you see and recognize this report?
Yes.
Okay. Can we turn to page 138? And do you see this as a table showing the kinds of difficulties customers experienced enrolling in LEAP, and that 37% of the company's electric customers that applied for LEAP in 2022 had difficulty in completing the application, 32% in providing income documentation, and roughly 1/3 were denied. Is that accurate on the electric side for public service?
I'm not sure that I would be able to tell you specifically to this level for LEAP customers. If we're talking about our programs, that might be different, but again, I don't have any reason to question those numbers.
Okay. And can you scroll down to the next page? Well, actually, stop there. You can see for PIP, there's somewhat similar numbers. They're a little lower, and it's across multiple utilities, but double-digit percentage of people struggling to enroll. Is that fair?
Yes.
And if you can go down one more page to 139. And you can see there's 18% couldn't complete the application, and there's other reasons. And again, this is LEAP, but I guess the only point I'm trying to make is that there's real significant barriers to opting into these programs. It sounds like you agree with that.
I would say that for us, because we auto-enroll customers from LEAP, I think that that's a barrier that we've kind of removed.
Okay, fair enough. But the LEAP barriers are barriers to get into your program.
They are.
All right, you can take this down. And just to complete the thought, it sounds like, would you agree that poor internet access, medical or cognitive issues, difficulties with reading or speaking English, lower education levels, or lack of sophistication also create barriers for customers to opt into these programs?
I would agree.
Okay. Is it accurate to say that the company disconnected over 53,000 unique residential electric customers for non-payment in 2025?
That is correct.
And can you tell me the median or average times that these customers were without power?
I do not have that information in front of me.
And Ms. Anstey asked for that information in discovery, and you were unable to provide it. Is that correct?
That would be correct.
And why were you unable to provide it? It seems like you have, the date the reconnect service went out, and you have the date the disconnect occurred. So I don't understand why you were not able to provide that data.
It's not that we can't provide it. It was just that it was not available in the manner that was requested. It is something that we can provide, with a little more time to put it together.
And can you tell me how many customers were disconnected and never reconnected?
I don't have that information in front of me.
And again, Ms. Anstey asked for that data and you were unable to provide it?
That is correct.
And again, can you help me understand why you couldn't provide that data?
One of the challenges with this particular request is that customers often move without providing notification. Sometimes someone might come in that we're not aware of. And so, it's difficult to pinpoint exactly whether a customer remains disconnected over a longer period of time.
Can we pull up your supplemental direct testimony from April 3rd, 2026 in the gas rate case? It's 25AL-0594E, hearing exhibit 129, which has been marked as hearing exhibit 1510 in this case. And let me just say, I appreciate the testimony. I appreciate you crossing both cases. So despite some of the other concerns I'm going to express, let me just say thanks for that. Do you recognize this?
I do.
Can we go to page 13, line 15? And basically paying 100% of their arrearage for those customers that were actually disconnected would cost $34 million. Do you see that?
I do.
Okay. And if we go down to page 14, you outline a proposal that would auto-enroll customers in the EAP or GAP, as well as providing 10, 50, and 80% arrearage relief based on the length of the arrearage. Is that right?
That's correct.
And ultimately, you find this proposal to be too expensive since it would cost an estimated $160 million. And I think that's at page 15, line 9. Is that accurate?
Just looking at it right now. You said line 9.
Yeah.
That's correct.
Okay. Well, prior to disconnecting any customer with, say, arrearages of 60 days or more, what do you think about auto-enrolling them in the affordability program and then offering more modest help? It seems like by limiting the number of customers and lowering the percentages of arrearage payment, it seems like we could help, without getting to numbers anything like this. We could do 0, 10, 20 for some subset of these customers. Any thoughts on that?
I actually think that's what we're going to get a chance to do with the current proposals that we have for the EAP and the GAP programs. One of the things that we spoke to staff about was the ability to try and get some kind of notification for the program for self-attestation and categorical eligibility, put that in some kind of noticing, and I think we could back that up. And I think we might see really good results with that. So we're pretty excited about the opportunity to try that.
You can take this down. I guess I'm asking a different question. Given the limited resources available, I'm struggling to see why it isn't better to focus bill assistance on some subset of the 53,000 customers you disconnected instead of a universe of whatever it is, 250, 300, or 50, or 450, where the funds seem to get systematically allocated to the most sophisticated customers that seem to need it the least. So I guess I'm trying to understand, why don't we just focus on disconnect instead of like hiring people to reach out to this huge universe? Why don't we just focus on who you're going to disconnect, since you know who they are? And um, so can you just help me understand why we can't focus on this smaller universe instead of this opt-in thing, which I think is potentially really problematic?
I think what I would say to that is this is kind of a philosophical question in a way. If you look at the universe of these customers that may be experiencing a disconnection, there may be many reasons why that's taking place. It may not be about energy burden. It could be, maybe there's mental health concerns in the household. Perhaps they're not staying there full time or something. There could be a number of reasons why someone might experience a disconnection. I think what we're really trying to address is those customers that are experiencing critical need. And imagine for those customers that we are not helping, or if we were not helping them, our disconnection rates could be much higher. And those are customers that really need the assistance. I can't say that we're going to prevent 100% of those disconnections, but I can say that we're going to prevent probably more than what you're seeing right now. And it will be targeted based on income and other factors in the household that we can identify. The other thing is that some customers may not reach out to us. They might be eligible for assistance. We are spending a lot of our time talking to them and trying to make sure they're getting access to those resources, helping them walk through those applications, because customers may need that help. We offer, obviously, other languages for applications, as well as our communications with those customers. Our goal is to interact with them and engage with them so that we can prevent more of that from happening.
Well, I guess my concern is that the opt-in may systematically bias the support to those customers that need it the least, because it requires significant sophistication to opt in. So that's the concern. Well, any comments on that?
We've been experimenting. We have a program in Minnesota that's mentioned in testimony, where we are allowing customers to self-attest and provide categorical eligibility information from another program. We've got over 20,000 customers in that program. And I would say that gives me hope that we are going to be able to address this. We will continue to do outreach to these customers, and I think our methods are getting more sophisticated in terms of reaching people right where they are. I think Red Truck is a testament to that. We've been seeing some very powerful results around that program, where customers can come up. We've got a computer there. We've got translation devices. We're reaching people at those events, and we're reaching them in other forums as well. And I really think that this is something that's going to drive more customers to programming.
Can you pull up hearing exhibit 1513? Let me represent to you that this was presented at a prior commission information meeting, and it's a Metro Denver Homeless Initiative State of Homelessness 2022-2023. And can you turn to page 72? And you can see there's a line, maybe 7 or 8 down, that says unable to pay for utilities is mentioned by over 12% of respondents as a self-reported cause of homelessness. So I'm not going to introduce this as evidence, nor will we rely on it, or will I rely on it in our decision. But are you aware of any information, other information on this record or elsewhere that explores the link between utility disconnection and homelessness?
I'm not aware of a study.
You can take this down. In the last, can you pull up hearing exhibit? Well, not yet. In the last electric rate case, actually pull up hearing exhibit 1514. In the last electric rate case, PUC order C230592, 25AL-0530E at pages 4 to 5 from September 23. We said, as discussed below, the commission modifies paragraph 70 of the settlement agreement to direct the Energy and Security Working Group to develop an outreach program to contact and interview disconnected customers to better understand their circumstances, their options after disconnect, the barriers and challenges to reconnection, and possible avenues of assistance, as well as efforts to explore new approaches for identifying customers most in need. If you could go to page 12 of this report, the company says it planned to start conducting interviews the first week of June 24, and to interview, you can just scroll down. I think it's the highlighted portions. Yeah, you can see we'll start conducting interviews the first week of June. Did the company ever conduct the interviews? And if so, can you point me to the results?
I believe it was filed in this report, although I don't know where it may have been filed, but we did conduct the interviews. It took us quite a bit of time to get disconnected customers to talk about this with us, but I don't know exactly where it might be filed in here.
Can you see if, as part of the record in this case, you can find that? I went through this record and these reports, and I couldn't find anything, nor was there evidence that the interviews were conducted. So if you could find that, that would be great.
You want me to look for that right now?
No. Before the case closes.
Yeah, I do have the results of those interviews, and so happy to provide that.
Yeah, if you would, that would be great.
Sure.
You can take this down. Can we pull out what has been marked as hearing exhibit 1516 from the same M docket that report was filed in? It's 23M-0013EG. And do you recognize this as the company's 2025 disconnection report data in Excel format as filed on March 2nd, 2026? And it's referred to multiple times in Ms. Anstey's answer testimony, footnotes 10, 53, 55, 83, two of our attachments, and page 27 of Mr. Piquet's rebuttal testimony. Do you recognize this, Ms. Howard?
I'm having trouble recognizing it only because the print is so small, and I don't know if there's any way to blow that up a little bit, but I am familiar with this report, although I have not studied it in preparation for testimony.
Yeah, fair enough. Do you see it now?
Yes, I do.
All right. Can we go to ABH customer account? Yeah, that one. And do you see that it's so you see it's by zip code, and if you can see column S, it's disconnection for non-payment. Does that look right to you?
Yes.
And S is for all customers, and T, if you can just scroll over a little, is for IQ customers. Does that look right?
I would assume so.
Okay. Can we go to cell A673, which is March 1st for zip code 811? A673, way down. All right, you see that zip code 811?
I do.
And if we scroll over to column S and T, Can we see what do you see the disconnections for non-payment are 477?
I do see that.
And that could be IQ or other customers. We don't know. The 13 is just the customers we do know are IQ. Is that fair?
That's fair.
Okay. Let me represent to you that we looked at disconnections by zip code. I looked at disconnections by zip code and identified the top 15 zip codes with the most disconnections, and found that 15 zip codes, or 4% of the 340 zip codes, accounted for 37% of the disconnections. Let me further represent that zip code 811 had the highest disconnections with 2946 in 2025. Someone else will need to verify all this, and I'm certainly not going to use any of this as evidence. But subject to later check, is there any reason to doubt that this type of calculation, rank ordering the zip codes by disconnects, could be done with this data?
I don't see any reason why it couldn't.
Okay. Can we pull up what has been marked as hearing exhibit 1512? Let me represent to you that this is US Census data tabulated at the website shown at the bottom of the page. Again, this is intended for the sole purpose of helping to frame our conversation, and I'm not going to introduce this as evidence or rely on it in any decision. Having said that, do you see how the top block refers to Colorado as a whole, and the second block refers to zip code 811? Do you see that? And maybe you
I can
can
see that. The data below it is a little bit difficult to read.
Yeah, if you can just scroll in a little.
Okay.
And go back to the top.
Okay.
And you can see that Colorado has 1.263 million people of Hispanic origin out of a total population of 5.774 million, or roughly 22% of Colorado is Hispanic. But in this zip code, if you scroll down, more than half of the 2020 population is Hispanic. And I guess the bottom line is that when you go through the disconnect data, it appears that the zip codes with the 15 highest disconnections appear to be either predominantly Black, Hispanic, or both. And all 15 seem to have disproportionately impacted census blocks within the zip code. So somebody besides me will have to go through this. And again, it's not going to be evidence. But my question to you, is there any data on this record or elsewhere that would contradict or address this concern that the company's disconnections are heavily concentrated in minority communities?
Based on what's been presented here, I would not refute that.
And are you aware of any data anywhere else that would refute that?
I'm not aware of any data.
Okay. Can we go down to the last page? Do you see that Verola, Colorado, 16.7% of respondents speak a language at home other than English, while in zip code 811, 51.4% speak a language other than English at home. Likewise, do you see that 47.8% of Colorado has a BA or higher, while the zip code 811, only 19.9% have a BA or higher? And again, yeah, oh, thanks. So again, we're not going to use it as evidence, but as such, it appears that zip code 811, as well as the other 15 zip codes by number of disconnects, have levels of education, income, access to healthcare, and English proficiency that are generally well below the state averages. Given our discussion about the barriers to opting into existing bill assistance programs, are you aware of any evidence on this record or elsewhere that would address or contradict this concern that opt-in bill assistance benefits may be systematically allocated away from the communities that appear to have the most concentrated disconnections?
I think what I would say is that because we are doing so much work to try and make everything accessible for customers, especially those that may speak a different language or have other challenges, and the work that we're doing to try and make sure that we're going to help them with those things. I would say that just the programming that we're talking about doing and what we're already doing, I think is going to help address this and has been.
You can take this down. So when I look at this, I'm concerned that disconnections appear to be concentrated in poor, predominantly Black and Hispanic communities, and that the bill assistance, given the opt-in approach, is being disproportionately allocated to zip codes with higher levels of income and language proficiency. I don't think it's against the tariffs or illegal, but does the company think it's acceptable public or good public policy to concentrate disconnections in poorer, less educated, predominantly minority communities, while perhaps systematically allocating bill assistance elsewhere because of the opt-in nature of those programs?
I don't think that's the case, if I'm being honest. I don't see that. What I see is that there's a certain threshold that customers can reach where they are eligible for disconnection. It does not have anything to do with any other determinants. But I don't think that we're targeting energy assistance elsewhere. I think we're targeting it everywhere.
But the people who are opting in, to opt in requires, it seemingly requires a certain level of proficiency in English, perhaps a certain level of education, a certain level of internet access, a certain level of health. And it seems like the communities where the most disconnects are happening are not the communities that are going to be able to opt in the best.
Well, we don't currently do any opt-in for customers, but as it stands in our plans, we will be addressing communities where there might be other barriers. I think we will do so through the additional outreach. We'll do so through materials that will be in other languages. I think there's a lot that we can do to make sure that we're addressing those needs.
Any thoughts if the commission were to ask staff to try and start looking into and maybe addressing some of the questions and concerns that we discussed today? Any guidance if we wanted to do that?
I think that we would welcome the opportunity to have a greater discussion and make sure that we are addressing things that the commission deems to be critical, because they're the same things that are critical to me in these programs as well as to the people that work in that department. So definitely, we're definitely interested in that.
I guess just one last question. Can you just help me understand why we can't do more with some subset of the disconnected customers? You know who they are because you're disconnecting them. Why can't we focus more on that and less on trying to get people to opt in to LEAP or other programs? It just seems like those are the people who need help the most. And I think a lot of those and who may have the most worst outcomes in terms of homelessness and may have the least ability to opt in. So just one last time, any thoughts on that?
I think that what we're getting ready to do is going to change those numbers dramatically. That's what I think. I will say that, we use an Experian model combined with information we have on past due balances as well as rates of disconnection. And those are the customers we're targeting for outreach. I think we're going to be able to do more now. And I think that sending applications forward, which obviously we haven't had, so we haven't tried it, I do think we're going to see results that are going to lower those disconnections, especially if you think about just what we're doing in the program itself by not allowing any disconnections while they're enrolled.
I know, but for people who can't figure out how to opt in for language or other reasons, you disconnect them and maybe permanently. What about auto enrolling somebody in the affordability program before you disconnect them? And then if they can't pay, maybe you have to disconnect people in the affordability program. but it just seems like so much hinges on the opting in. If you opt in, you can't be disconnected. But if you can't figure out how to opt in, you just get disconnected without any help. And it does seem like they're targeted at minority and DI communities. So
I think that we need to explore this further. We need to see what these programs can do with these changes, but I think we're definitely willing to explore any options that are going to help customers avoid disconnection of service. Absolutely.
It just seems, well, all right. Redirect.
Thank you, Chair Blank. I have a few questions for Ms. Howard. Ms. Howard, do you view programmatic bill assistance to be a static proposition? And does the company have the flexibility to adapt to address concerns such as those raised by Chair Blank?
We do. We definitely have the ability to make changes.
Would the company's proposed EAP enhancements as adopted under the settlement agreement expand and simplify EAP enrollment pathways, even for those identified by Chair Blank?
It will.
Would customers facing disconnection be able to self-attest to their income and enroll in EAP under the proposals made by the company and the settling parties?
Yes, that's correct.
Going back to the data-related issues, is the calculation of time disconnected a straightforward calculation?
It is not.
Could you expand on that a bit, please?
I can. There are many intervening factors for how long someone is disconnected, whether there's any interruptions to that. I would say that, in terms of customers experiencing a disconnection, again, there may be reasons why maybe they're, struggling with other issues, including moving to another place or something along those lines. So there's a lot of factors involved in what happens with customers through disconnection processes.
Thank you. As part of the settlement agreement, has the company agreed to further look at trends related to enrollments and disconnects?
Yes, we have.
And the company has recognized that looking at disconnects along with the settling parties is an important area to further explore. Would you agree with that?
I would agree.
Would the company's proposed EAP enhancements as adopted under the settlement agreement prevent disconnections for customers enrolled in EAP?
Yes, it will.
Or that are otherwise income qualified?
Correct.
You're familiar with the settlement agreement's provisions on EAP enhancements, Ms. Howard?
I am.
Would you like to expand at all on the benefits to our customers from the provisions agreed to in the settlement by the settling parties related to EAP?
I would say there's a number of elements to this. One, the issue that we've just talked about in terms of preventing disconnection, lowering energy burden or wallet share for customers who otherwise can't afford their rates, and making sure then that they're able to afford other things. It's going to enroll a much larger number of customers based on that. So I think those are just a few. I can certainly go on with more, but that's a good start.
Thank you. I have no further questions.
Thanks so much for joining us today, Ms. Howard. And if you can have your counsel supplement the record with what you find in response to those interviews, I'd love to see it before we talk to Ms. Anstey and Mr. Bennett. So thank you.
Thank you. Thanks for having me.
Ms. Samard Pacheco, who's next?
I think it's Mr. Goodenough, and my colleague, Ms. Brahma, will be defending Mr. Goodenough.
I doubt it'll amount to a defense, but Mr. Goodenough, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. And is anybody with you or communicating with you in any way?
No.
And if that changes, you'll let us know?
I will.
Thanks.
Good afternoon, Dr. Goodenough. Would you mind stating and spelling your name for the record, please?
Yes, my name is John Goodenough, JohnGoodenoughh.
And for who do you work and in what position?
The Director of Sales, Energy and Demand Forecasting for Excel Energy Services.
And did you cause to be submitted into this record, hearing exhibit 120 as your direct testimony and hearing exhibit 150 as your rebuttal testimony?
I did.
I don't think you have any additional corrections today. Is that correct?
That's correct.
All right. And with that, Dr. Goodenough is available for cross-examination, or it sounds like commissioner questions primarily.
Thank you. Didn't realize you were Dr. Goodenough. Commissioner Plan, any questions for Dr. Goodenough?
I do not have any questions.
Commissioner Gilman.
Yeah, hi, I have a few questions. Good afternoon, Dr. Goodenough.
Good afternoon.
Just a few questions first about kind of general sales trends that you're observing, so I can be sure I'm on the right page. In your direct testimony, you had discussed that after normalizing for weather, the company's total electric retail sales have declined slightly over the past 5 years. Is that accurate?
Yes, that's correct.
Okay. And then you do indicate, I think you made a revision here, maybe in your direct, that from 2019 to 2024, you've seen an average residential growth rate of 0.8% per year. Does that sound right?
Yeah, that's correct. And that revision was just clarifying the time frame of the average growth from 19 to 24.
2019 is not on the
Yes.
table, but it
Right.
was necessarily used. Got it. But just to clarify, despite how that averaging works, the residential sales for 2024 are still lower than they were in 2020, correct?
Yes. So we saw during that time, we saw a jump in residential sales with people being at home during COVID. And then we've kind of seen that work its way back down to the overall long-term downward trend, kind of as we've returned to normal, people go back to work, those sorts of things.
Okay. And so in that, I think the phenomenon you're talking about in that table, in your direct, you actually show a decline each year since 2021 through 2024,
Yes.
right?
That sounds right. Yes.
Okay. And also in your direct, you mentioned that you get a monthly forecast of the impacts of new BE programs, beneficial electrification programs, from the DSM regulatory and strategy and planning department. No, that's what it calls it in your testimony. Based on observed adoption since the introduction of these programs. Is that accurate?
So we get a forecast of monthly adoptions. We don't get the forecast on a monthly cadence. It's a forecast of monthly impacts due to adoptions.
And does that include like actuals for what has been observed, and then it kind of recalibrates a forecast going forward?
Yeah. So it's for the purposes of this proceeding where we were forecasting really the rest of 2025 is largely what I'm describing here. And the forecast that was provided by that team, I won't try to say the name again, really looked at recent adoptions, like the trends in recent adoptions, and kind of extrapolated that through the end of the year. So really the beginnings that we're starting to see of electrification extrapolated an additional 6 months.
Okay, got it. Have you provided that portion of the forecast separated out anywhere?
I don't believe so.
Okay, I know in other proceedings there's been interest in looking at the forecast of these things coming, and since you mentioned you get a discrete one, I was just wondering if we had seen that, but it sounds like no. In your direct testimony, you included essentially actuals through June for 2025, actuals from January to June, and then forecast from July to December, correct?
That's correct.
Okay, and then in your rebuttal, you provide then a comparison between those forecasted July to December monthly sales and the actuals.
Yes.
Okay. And as I understand it, I'm just trying to better understand what forecast was used in your direct to come up with the July through December. It sounds like there's a semi-annual or like a twice annual revamp of the forecast. Can you help me understand when that's done and what all feeds into that that reassessment of the forecast?
Yeah, so just as standard practice, we update our forecast twice a year. It'll be a finalized forecast in March and then a finalized forecast in July. For a couple months ahead of that, we're developing the forecasts. So the forecast that was used for the remainder of 25 in the direct case was that forecast that we finished in July.
Okay, so you said one's finished in March and one's finished in July?
That's right.
Okay, so not necessarily at an even interval through the year.
Yeah, not semi-annual, I guess, but there's a kind of a spring forecast and a summer forecast.
Okay, got it. So and that's when it's like done.
Yes.
So in March of each year you have a new results, and then in July of each year you also have new results.
Yep, that's correct.
Okay, got it. And so this this was utilizing that July forecast from 2025. So that would have been informed by actuals for the first half of the year?
For sales and customer accounts, yes. For some of the kind of adjustments that we make after we run those base models, like electric vehicle counts, perhaps this beneficial electrification adjustment, I would have to go back and see like kind of when they're trending, the data they had as they were developing the trends that they were passing us along the forecast. It might have been the end of 24, not the first few months of 25, where we had actual data to develop those external adjustments to the forecast.
Okay, got it. And then I know for here, the objective was 2025 to understand how the test year looked, but I'm curious, how far out do you run when you do those reassessments of the forecast? Like, does that reassess the entire future of the forecasting that you have? I know for other proceedings, you do much longer range forecasting than here.
Yeah, so every forecast iteration we do is a 30-year forecast.
Got it. Okay.
Yeah.
Okay. So you just sucked out the 2025
That's
portion, but like in reality, it reassessed much longer than that.
That's right.
And I'm curious, is this the same forecast that would be used in like the JTS and DSP type proceedings, planning proceedings before the commission?
No, it is possible we would make changes, and I think it's the nature of what you described with focusing on kind of the last 6 months of the year versus a longer run planning forecast. So we potentially could make different assumptions on large loads in the longer term planning forecast, different assumptions on the timing and the pace of electrification, among other things. Electric vehicle adoption could potentially be different in a longer term outlook used for longer term purposes.
Okay, so like safe to say, the further on the future we're looking, the more fuzzy the accuracy of these estimates are. But the closer we get to the future, the more we're using like nearer term understandings of what's going on.
I think in general forecasting, that's a true statement.
Okay. So on page 7 of your rebuttal, you in this proceeding, you show kind of this comparison between the forecast, which as I understand came from oh, thank you. There it is. Came from the July iteration, so halfway through 2025.
Yes.
So you had forecasted what the remainder of 2025 would look like, and then compared that to the actuals. And it looks like the actuals were just a tad higher in total than the forecast.
Yes, I agree.
Okay. And then I wanted to understand what the total 2025 sales looked like. Maybe there was somewhere this was, but I went back to hearing exhibit 120 attachment JMG1, where you showed the actuals for the first half of the year and just blended it with the actuals for the second half of the year. And and their, let's see, I came up with 28, let's see, 28, are we gigawatt hours or megawatt hours here?
Megawatt hours.
Megawatt hours, all right. Then 28,797,840 megawatt hours for total retail sales for 2025. Does that sound reasonable?
It does, and I believe there's an attachment to my rebuttal that shows the full year of actuals, and if you're not spot on, you're very, very close.
Okay. It's in the neighborhood. So I went back, I was just curious how this compared to what we've seen in other proceedings. And actually UCA had submitted the direct testimony JTS forecast, which I think they had marked as hearing exhibit 302, attachment LHS 38. And in that on page 45, you can see here total retail sales. So at that point in time when this was submitted for the JTS, the forecast for retail sales was 32,810. Now we're in gigawatt hours.
Yes.
You see that?
I see that.
Okay. And then I will say also, I have provided to Ms. Frederico your rebuttal from the JTS, which I think we've pre-marked as hearing exhibit 1519, which shows a similar table updated in your rebuttal on page 17 of that. And hopefully we can get that up, but the number, page 17. The number increased to 33,373 megawatt hours there. Do you see that?
I do.
For total retail? Okay, so
Yes.
essentially between the direct case and rebuttal case, we had about a 1.7% increase in the total retail forecast in the JTS. Does that make sense?
Yes.
Okay. But we have compared that to this is the most recent that we had in the JTS. This was submitted in May of 2025.
Okay.
And this was 33,373 gigawatt hours as the forecast for 2025. And we were nearly halfway through the year when this was submitted. So that is about 13.7% higher than the actual sales in 2025. Does that sound accurate?
Well, so a couple things to note here. It's not apples to apples. So first, in the JTS, it's energy, not sales. So we're adding back the line losses. So that's going to add 6-7%, somewhere in that range, most likely, to a sales forecast or an energy forecast. And then the second piece is in the JTS, it's native. So we're also adding back the impact of solar. So they should be pretty different.
Is there any place where I can see that comparison?
Not in the record in this case, I believe.
Okay. I'm trying to understand, we get forecasts across all of these different proceedings and they are different values. So I think it's increasingly important for the commission to be able to compare these values across different proceedings to understand what's being presented in each.
Understood. We can take that as a note to maybe just include in one or the other, we can include the other concept as well as a point of comparison.
Okay. Yeah, that would be very helpful just so we can look at how actuals are actually stacking up to these forecasts, because it seems like we have somewhat incompatible data is what you're saying. And I would really appreciate the ability to be able to compare it side to side.
Okay, understood.
Awesome. Those are my only questions. Thanks so much.
You can take that down. Dr. Goodenough, would you be willing to provide an exhibit in this case that shows the difference between the ERP and the rate case, sales to generation link so we can see that? Could you do that, sometime in the coming days?
Yeah, we can certainly provide the sales from the JTS, kind of the lower concept in JTS. I'm thinking through if we have like the final solar numbers for 2025 to get to a native, but just at any point, any anchoring point, we can provide the sales from the JTS.
Yeah, and it doesn't have to be perfect. If it could just
Okay.
be indicative so we can understand. Can you pull up hearing exhibit 152, JMG 8? And I think this is the document you referred to with Commissioner Gilman. It's 2025 actual sales and customers. And I think Commissioner Gilman quoted 28,797,841. Yeah, you see
Yeah,
that?
this is what I was referencing. That's correct.
And this is, I think, the tab number in the Excel spreadsheet says 2025 actual sales and customers. Would you accept that is how it's labeled?
Yes, I would.
And I'm just going down a little bit of a different path. This is all weather normalized, so it is not actuals, right? It's not actual sales, it's weather normalized sales.
It is weather adjusted as labeled. I think I was trying to like draw the line between actual weather normalized sales and then the forecast that we had initially provided.
Understood. It seems like all the financial documents, the 10Ks and the investor presentations, assert sales grew in 2025. But I think when you look at actual sales, it actually declined, I think, by almost a decent amount. And I guess two questions. One, do you have actual sales anywhere on this record or anywhere? Everything I saw was all weather normalized.
I believe everything in this record would be weather adjusted.
Well, maybe as part of responding to Commissioner Gilman, could you present actuals? And I'm not saying it's not labeled correctly. I guess the reason I'm asking is because I just wonder how confident you are in the weather normalization. I mean, it seemed like it was a really hot year. It seems like there's been multiple really hot years. And, are we weather normalizing these sales based on data back 20, 30 years when the same patterns may not hold? Can you just talk a little bit about the weather normalization?
Yeah, so our current weather normalization process uses coefficients from 15-year regression. So it's monthly observations for 15 years. It's not perfect. We'll certainly agree to that. And particularly when you see extreme weather, so a warmer month than you've seen, a warmer winter month than you've seen in the last 10, 15, 20 years, those kinds of things. The model kind of breaks down at those tail ends. It does a better job in, weather that's been observed frequently over that period of time. I would have to go back and look at the adjustments we made and providing actuals would allow you all to do that as well. I think we ended up adding a lot back in the winter months because they were milder than normal, more so than you were mentioning some hot summers. I think we were taking sales away in the summer months, if I remember correctly. But yeah, it's certainly we have faith in the estimates. We think they're good estimates, but they're not perfect, particularly when you see that extreme weather.
Well, if you could just do the actuals versus the weather normalized for the last few years,
yeah,
that would be valuable to me. I'm just not sure what normal weather is right now, and just trying to make up my mind what the story is and what's going on, because certain documents talk about increases when actuals decrease. So that's all I had. Redirect, Ms. Brahma.
No redirect. Thank you.
Mr. Goodenough, you may be excused. Thanks for joining us today.
Thank you.
Let's see who's next. I think we'll call it a day. Any final things before we break?
Yes, Chair, I do have a couple of questions. If I recall correctly from this morning, I believe Commissioner Gilman wanted to reserve Yen Lee if she didn't get the answer she was looking for from Mr. Piquet. So if I remember correctly, I just wanted to see if we still need to have her available tomorrow.
No, she can be excused. Thank you.
Thank you very much.
And how about Ms. Allison, I guess is the next one.
Right, it was a little unclear to us whether AARP still has, we may have misheard. We don't know if they still have cross for Miss Allison or Miss Doyle.
I think we've excused Ms. Doyle. I think AARP did not have questions for Ms. Allison, but I think Commissioner Gilman may have.
That's correct.
That is correct. That is correct. And I can also, I believe I can waive Mr. Salazar and Mr. Digel.
I have questions for Mr. Deagle.
Okay.
And it looks like Boulder has questions for Mr. Salazar.
Yeah. Okay.
So it looks like tomorrow we're going to start with Ms. Allison, go to Ms. Lovely, Salazar, Deagle. We excused Watson, and then Mueller, McCone, Hanson, Nickel, McGregor, Miller. Miller, I think, is excused. Freitas. So is that consistent with your witness order and where we're at, Ms.
Well,
Smart?
Sorry, Chair. My witness order is slightly different. I do know Mr. Hanson is not available on Friday, so he will need to go on Monday.
Okay. Okay.
And I believe Chad Nickel also.
Is Monday.
I'm checking, or yeah, Monday or Tuesday, but I think he is also unavailable tomorrow.
Okay.
As is Paul McGregor. I did have a question. It looks like there's only 5 minutes reserved for Paul McGregor, and I'm wondering if we need to bring him in for that.
I think that's up to Mr. Kaufman.
It is up to Mr. Kaufman, yes.
I can waive my questions of him.
Are you sure? You don't have to.
No, I'm sure. I'm sure. Yes.
All right.
I don't have any questions for him either.
Okay.
How about you, Commissioner Gilman?
I don't. And I did just want to, sorry, long day.
Yes.
In response to the questions about order, I'm expecting that if we need to bring Miss Lovely, it'll be after Mr. Freitas, because I'm hoping he can just answer the questions. So just a note on that order.
Correct.
Okay.
And we've checked on her availability. It doesn't look like we have any problems with her availability, so that should be fine.
Okay. Let me try again. So we got Allison, Salazar, Deagle, Mueller, McCone, Freitas, Lovely. Is that right?
Yes.
And then we'll start Monday with Pascucci, Wenner, Buckley, Hanson, Nickel.
That sounds fine with us, Your Honor. And I just wanted to confirm, did we 100% confirm that the commissioners don't have any questions for Mr. McGregor? Just
I
want
do
to make sure.
not.
Okay.
Commissioner Plant?
No,
Nope.
I don't.
I don't.
Commissioner. All right. Ms. Nelson.
Yes, Chair Blank, I just want to let everybody know that UCA has waived Mr. Mulber. And to the extent we need any time, we can move that 30 minutes over to somebody else. But just for planning purposes for tomorrow, we won't be asking him any questions.
All right. So we'll see. Tomorrow may be an early day. I don't think we put staff on till Monday. So that maybe that helps Ms. O'Neill plan, or at least I won't be ready till Monday. All right. Any other matters before we break for the night?
Not from the company, thank you.
All right. Thanks all. See you tomorrow at 9 a.m. 9 a.m.
Thank you, Your Honor.